Paper book is ready, my lord. Export hearing. The order was passed on the last occasion also.
That order is already there.
Yes,
It should come in hearing.
Hearing.
Because paper book is ready.
Paper is ready, appeal has been admitted,
yes,
furnished to both the parties.
yes.
Actually, the reason it is listed because we have filed an objection in IA. That's why.
We'll take up the.
Yes,
Yes, main appeal, Your Lordship.
Only PW 12
Yes,
is the evidence against him.
yes.
The learned counsels for both the parties are present. It is seen that paper book is ready and duly furnished to both the parties. In view of the above, this matter is to be listed under the hearing column. List after
3 weeks.
Can it, can it be next week, my lord? It's been
Next week
discussed.
may not be possible.
2 weeks, after 2 weeks.
Yes, sir. Obliged.
Item number 2,
So no hearing. Everything.
My lord, in item number 2, this morning, the executive engineer has submitted a voluminous status report. I would just have a slight glance justifying and annexing all the,
Have you given a copy to her?
not yet, my lord.
Give her, let both of you respond, I think.
Yes, my lord.
You are also not, have not gone through, I think.
Yes, my lord.
That's.
Only the thing that on the last occasion,
Hmm.
and there was a bar chart also to be made, my lord, fixing when the work would be complete, my lord. And what is the,
What is the present status?
So you have to address to all the queries
yes,
or information that is required
that has,
as per this court's order.
yes, yes.
So have you filed in your affidavit, which is filed
No,
now
my lord,
today?
this-
Have you addressed to all the,
Yes, in this
Point.
status report,
uh,
the officer has addressed all the queries. It starts from page 4. Queries of this honorable court, my lord, as per the last order.
so I think a copy should be then furnished to the
Yes, madam.
petitioner. Let them have a look at it. and then
Otherwise,
we
what
can
is the
see,
condition?
Now, since it was a monsoon season going on, now they are starting again. And they are, as per this bar chart,
Monsoon season is gone in the month of August.
my lord, it was, they were supposed to start by October, this October.
Whether they have started. We are on almost end of the October.
My
Yes.
lord, as per the information from the petitioners, they are saying that there are no works are going on still.
And as per the bar chart, my lord, if my lord, last page, my lord.
Okay, madam, you respond.
No, you get a copy first.
Yes.
Oh, my lord, they are supposed to start from
Yes,
1st of
yes,
November.
Yes.
Sorry, my lord.
Naharlagung Road, is it?
Yes, yes, yes.
Then there was another issue which I don't know, it's not been taken up in the PIL, but concerning the disposal of the waste materials.
Yes. My lord, now that,
I'm
that
thinking
stage is over.
Along with that.
Because that stage is over, because the art cutting work, formation cutting is over. My lord, now the remaining is the WBM and black topping. Formation cutting, that is over. I'm sorry, my lord, they are as per this bar chart. Yes,
Yes,
1st of November, they are supposed to start as per this bar chart.
First of November.
November.
So we'll give the date thereafter.
Yes, ma'am.
Madam,
Yes.
you also go through it. What
Yes.
is your objection and all, if necessary, file and sort affidavit.
go and have a, what verification also.
Hmm.
Whether what is being
That will be the-
mentioned in the affidavit is actually
Yes.
correct on the spot, isn't it? Heard, Mr.
May I
And
please, your lordship, I'm appearing online on behalf of the contractors, lordship, 12 and 13. 13 and 14, lordship. So we are newly engaged, so we may be allowed to file our affidavit, lordships. Because we can give the proper what
okay,
is
the status
Contract.
report proper as to what the contractor is doing.
Yes.
Yeah, okay, yes, yes. Heard Mr. N. Ratan, learned additional AG for the state respondents, who submits that he has filed the affidavit.
Status report.
In terms of our debt also.
It's not in the form of a affidavit.
Not in the form of
Okay.
an affidavit.
He has filed the status report in terms of this court's order dated 17/09/2024, addressing to all the observations and queries
Two status.
made by this court this morning itself, and that copy will be furnished to the learned counsel for the petitioner during the course of the day. Mr.
D Deka, Lordship, D
D.
Deka,
Deka, learned counsel for respondents number
13 and 14, Your Lordship.
13 and 14, being the contractor in the instant case, also submits that he may be allowed to file an affidavit informing this court of the present status of the works to be executed by them. In view of the above,
My lord,
this matter.
there was another status instruction to be sought, my lord, from the
Regarding the petition.
Mhm.
See the next page.
Mhm. So no physical verification.
So do it and give it.
Oh,
yes, this another
Physical
instruction was
verification.
sought from the disaster management.
Ah.
That has been also obtained, my lord.
That is not. the-
No, this one, instruction only. Whether,
They have not physically verified.
yes, they only, what I have spoken to them, the public, they inform that disaster happen here. So wherever there are disasters, they go and physically verify
Mm.
where losses are caused to the public. Now, this was by the,
This is not the thing is that it is not the job of disaster management to wait and let a disaster happen
Exactly.
and go.
yes, my lord, exactly, that's why they should have, what their,
Yes.
yes, they should have gone there and,
So let
Ah.
them go and file a report in this regard also.
yes, my lord, that's why I've spoken to them. They, since there is no manpower and the disaster occurred, they are saying, but we couldn't go and verify this, but there was a WT
Close
measures.
the department.
Yes.
If no thing is no.
Exactly, my lord, that was, I was also surprised.
so
Because-
you're representing the department anyways.
Yes, my lord, this is the instruction from the disaster management
Oh,
department.
oh.
This
So
WT
however,
was
no
received,
physical verification was made by the undersigned.
WT message was received, saying that the fresh flood happened on 30.
Wait, affidavit is to be filed by respondent number so and so. The learned additional AG has also submitted a report with regards to received from the executive engineer, is it PWD Jayan Toga, reporting the damage of construction of material blockage of various drainage in between Sefa, Cheyang, Togo.
Taju, Chiang Taju.
Okay, the pronunciation, yes, okay. However, it is seen that no physical verification assessment was made by the undersigned. In view of the above, the learned additional AG is to get a report regarding the physical verification with regards to the damage of the said road, that is Chepan Chayongan Ajan, or whatever,
Yes,
that's same this thing. Okay, my pronunciation.
I'll get it.
Mm.
I will.
List the matter after 2 weeks
2 weeks.
on. Yes, when do you want it?
Start from half of November, maybe middle of the November.
Give us a date when you
On
will be
eight-
ready.
18, my lord.
18/11/2024.
Obliged.
Highly obliged, Your Lordships.
May I please, Your
Okay.
Lordship? Your Lordship, service report is still awaited
Who is
with regard to
respondent
respondent number two.
Who is respondent number 2?
Your Lordship, she is the complainant here in this case.
So we'll await for service report. Heard, Mr.
E. Minjo, Your Lordship.
P. So and so, learned counsel for the appellant, who submits that service report upon respondent number 2 is still awaited. In view of the above, list after 2 weeks, awaiting for return of service report upon respondent number 2.
Obliged.
May my lordship, I beg to mention item number 9. This matter is listed after 3 weeks. I have taken consent from the petitioner.
Yes, are you representing the petitioner? Is there some other case? Okay. Miss
K. Wangu,
K. Wangan, learned government advocate, is it for this respondents?
number 1.
Number 1 has prayed for adjournment of the matter and submits that she has taken the consent of the counsel for the petitioner. In view of the above, list the matter after
3 weeks.
3 weeks.
My Lordship, I beg to mention item number 8. And here we are the respondent, appearing on behalf of M. Kato. We have not received any instruction from the department.
Who is for the petitioner?
My Lord,
You're for the respondent.
Yes, respondent,
Okay,
yes,
who is for the petitioner? Anyone? You're for the petitioner?
No, man, I am for the respondent.
You're also for the respondent?
respondent, for the, yeah,
What? You are appearing on behalf of
M.
Mr.
M. Kato.
M. Kato.
Yes, my Lord.
Mention is made on behalf of Mr. M. Kato, learned counsel for the petitioner for adjournment of the matter. Anyone for the petitioner which is not objected by the learned counsel for the petitioner? In view of the above, list after
Should be.
2 weeks.
Should-
My lord, can it be on 11th of November, man?
Okay, list in view of the above, as prayed for, list on 11/11/2024.
Alright.
Obliged.
May I please, Lordship? Lordship, I beg to mention one pending matter to be listed today. Lordship, I would like to withdraw,
The urgency,
I would like to withdraw the matter for withdrawal. only.
very good, whatever listed today.
Yes,
What's this? This is a writ petition?
yes, Lordship.
Lordship, in this matter, I am appearing for petitioner, Your Lordship. Your Lordship, the present writ petition has been filed by the petitioner herein against the respondent number 1 to 5, Your Lordship. Your Lordship, in this matter, the petitioner herein has filed a writ against the respondent herein for the plea that the respondent number 1 to 4, who are the government officials, Your Lordship, transfer the fund in the escrow account, Your Lordship. Your Lordship, I just like to give a brief about the petitioner as well as respondent, Your Lordship. Your Lordship, the petitioner herein is a company by the name B4B Solutions, Your Lordship, which deals with IT solutions, Your Lordship. Your Lordship,
Yes, with?
IT solutions.
Okay, IT solutions.
Lordship.
Huh.
And services, Your Lordship, relating to IT products, Your Lordship. Your Lordship, the petitioner herein and respondent number 5, both have entered into an agreement, Your Lordship, to take a contract from the government, Your Lordship. Your Lordship, for that, an agreements were done, Your Lordship, which are annexure number 1 and 2, Your Lordship. Your Lordship, in the annexure number 1, may be seen, Your Lordship, wherein the responsibilities of the petitioner and respondent number 1 were divided, Your Lordship, which is known as teaming agreement, Your Lordship. Your Lordship, in the said teaming agreement, it was decided that what are the rules, regulations, responsibilities, and considerations, Your Lordship. Entire facts were mentioned in that, Your Lordship. Your Lordship, after entering into a teaming agreement, there was an JV, Your Lordship, which is annexation number 2, you may be seen, Your Lordship.
An extra?
Number 2.
Hmm.
Your Lordship, in the annexation number 2, which was done between petitioner and the respondent, Your Lordship, stating that the petitioner is going to take
Private respondent.
private respondent number 5, Your Lordship,
Hmm.
in which it was clearly mentioned that the respondent is going to have a stock of 49%, and an unofficial respondent number 5 is having a stock of rupees of 51%, Your Lordship. And other details were mentioned in that agreement, Your Lordship.
Hmm.
Your Lordship, after in that agreement also, Your Lordship, on page number 27, Your Lordship, it was clearly mentioned that once we get a contract from the government, and a separate escrow bank account shall be jointly created by the parties to manage project payments, Your Lordship, immediately. Your Lordship, in the said agreement, it was clearly mentioned that once a contract is granted to petitioner and respondent number 5, a separate bank account will be created in which the respondent number 1 to 4 are going to transfer this amount, Your Lordship. Your Lordship,
Transfer amount, that is 49% and 51%.
entire amount is going to be transferred in the escrow account. From there onwards, it will be distributed.
Okay.
First, the amount has to be transferred into the escrow account.
Into what? Escort?
Escrow, which is a joint account, means
Okay, there's a joint account.
Joint account.
Okay.
Your Lordship, the
huh.
details were given by the petitioner and respondent, Your Lordship, which is exhibit number 4, Your Lordship, wherein we have clearly given a letter to the mission director, Your Lordship, stating that this is the account which has been opened.
Hmm.
And
Joint account.
joint
money
account
to
has
be
been- yes,
transferred
yes,
there.
yes.
Okay. Understood.
This is the joint account has been opened, and the department should transfer the entire sum in that particular account only, Your Lordship.
Okay, department is an
1 to 4.
party to that agreement?
Yes, yes, Your Lordship. Annexation number 3 may be seen, Your Lordship,
Okay.
in which both of us, along with the department, we have signed
Petitioner
that.
and all the respondents have signed.
Yes, Your Lordship.
Okay,
Yes.
fine.
As such, Your Lordship, annexation number 4 may be seen, Your Lordship. We have given a letter jointly, we as well as King Constructions. We have given a joint letter to the mission director stating that we have created this bank account and the fund has to be transferred in the said account only. We have clearly mentioned, Your Lordship. The said letter was given on 12/9/2022, Your Lordship, in the year 2022. Your Lordship, after giving this letter also, Your Lordship, what the respondent number 1 to 4 has done is, they have transferred the entire sum only in the account of the unofficial respondent number 5, Your Lordship. Your Lordship, the amount which
Okay,
was,
respondent number 5,
yes, Your Lordship,
is he a person of the state,
yes, Your Lordship,
a company belonging
yes,
to the
Your Lordship.
Arunachal?
Yes, yes.
Okay.
The entire sum was transferred in the account of unofficial respondent number 5, Your Lordship.
What is the name of respondent number 5?
Kengi Constructions, Your Lordship. KCC.
Hmm.
Your Lordship, the fund which was transferred by the department to the Kengi Construction is to a tune of 60 crores, Your Lordship.
Hmm.
Your Lordship, we have given more than 30 times, we have issued notices, letters that the amount may be transferred into the joint account, but the department has not taken our plea, Your Lordship. What they have done is they have transferred the entire sum in the construction KCC account, Your Lordship. As such, upon the direction of the Honorable Court, we have filed a separate money suit also, Your Lordship, for the fund which was already transferred. Through this writ petition, we request the Honorable Court to pass an orders to the respondent number 1 to 4 from here onwards. Please transfer the amount because the contract was given for a period of 5 years, Your Lordship, out of which only 2.5 years over, Your Lordship.
So there's already a money suit
Already there,
pending before.
upon the
which
direction
court?
of the Honorable Court, we have
Ah.
filed a money suit also, Your Lordship, for whatever amount we
In the
have to get.
district court.
Yes, Your Lordship.
Okay.
Opposite. We have filed a money suit, Your Lordship. We have filed this writ petition,
So the writ petition is not about the money which has been transferred.
already transferred.
Huh.
Yes, Your Lordship.
So this is for future.
Future, yes, yes.
Future
The direction,
specific-
yes, Your Lordship. Our plea is, before the Honorable Court is to direct the respondent number 1 to 4 From here onwards, transfer
But
into
what
the.
happens
Yes, your lordship.
if the respondents
Yes, your lordship.
between both of you, if you have an agreement, take an undertaking that future money will not be transferred, then this case is over.
We have given several times, we have issued notices, several times we have given letters, but the department is not hearing to us. Because.
But no money has been transferred besides the, what is the amount you said, 600 crores, is it?
60 crores.
60 crores?
Yes, your lordship.
Besides the 60 crores, how much money is still due to be
It is around,
released?
it is going to be around 30 to 40 crores more, your lordship. Because.
Okay, 30,
we-
40
yes,
crores.
Yes, your lordship.
And no steps have been taken yet.
No step, yes, your lordship. From 2022, we are issuing notices.
So if the money suit itself is settled, it's going on.
Yes, your lordship.
So
is-
all you need is an assurance,
Yes,
is
your
it?
lordship. Yes, your lordship.
From the respondents?
Yes, your lordship. Just an assurance that from here onwards.
Is
the-
it? Wait,
My-
let's see.
Yes,
If it's
yes.
as simple as you
Yes, yes.
project.
My lord, at very outset, when the matter was taken up for the first time
Mhm.
on 2nd August 2024, the maintainability of the writ petition was raised, man. Yes, ma'am. The writ petition, the prima facie writ petition is not maintainable. So far, my lord, this all is relates to the dispute arising out of contractual agreement for which the writ petition is not maintainable. So far regarding, my lord, the billing part is concerned, this both, my lord, Kenge Construction and before it IT Solution Private Limited, for a billing part, my lord, there should be a GST joint account GST. Without GST and PAN card, bill cannot be processed, my lord. Now, since they are private, both are private party, my lord, it's up to them, their partner. My lord, so far,
You're
our
representing which department?
health department, man.
Health, okay.
But within the health department, there's a direction and IT income tax department. For that, we have to be, there should be a GST, my lord. GST problem is there. So that's why, my lord, this whatever the bill, my lord, that was, it is purely their dispute, my lord. So for sharing part is concerned. Now at very outset, when we say that when this writ petition itself is not maintainable under 226, my lord, it's a futile exercise going into all these aspects. And moreover, they have already filed the
There's a money suit.
money suit,
pending
and this is
already.
abusive process of law, my lord, this writ petition.
That's what I'm wondering. There's a money
Well,
suit
Let
already
him, let him
pending.
complete. I'll submit it.
None of your rights have been violated as of yet. This thing is your apprehension, which may not happen also if, as per the submission made by the Learned Counsel for Health Department, the issue of having some GST, which I'm not very thorough as to what is the system.
Your lordship, they should have told us in the year 2022
Oh, so
itself.
now you know.
Till now,
So the extent
recently
is-
we came. Yes, your lordship, on the previous date we came in to know.
Mhm.
Your lordship, from year 2022, we were requesting them. Sir, what is the issue? Why you are not transferring in the joint
So I
account?
think it's communication.
They have
So now
never approached. We have sent a letter many times. They have never personally came. They,
Yes,
Your
yes.
lordship,
That's a
kindly
one
see,
step,
I have
yes.
given, I have submitted several letters from our
Huh.
side to the department, lordship. We need assurance that from here onwards,
Yes.
as far as
yes.
previous issues are there, it will be settled. Your lordship, I am submitting it, there is a
What?
the Supreme Court, your lordship,
Ah,
which
okay.
clearly states that under Article 12, if at all there are any violations in the contract,
Hmm.
and if at all there is any malified intention, because your lordship, they are stating that there should be some GST income tax issues, your lordship. They could have told us in the year
Yes,
2022.
okay. So I think this matter can be settled since
Yes.
now you know.
Yes.
Now you know what is
Yes,
the
yes.
problem.
Yes, your lordship.
And there has been no violation of any fundamental right or any of your rights as of now. Because your previous grievance concerning the deposit of money
Yes.
to respondent number 5, that is going to be taken care of in the money suit.
Yes.
So now there's no case.
Well, there's no case. Well, regarding the
Now there's no
maintainability.
case.
Man-
Since you know the problem
Yes.
now, I
Yeah,
think
ma'am.
let's sit together.
Yes,
talk,
ma'am.
and
Your
finish
lordship.
it off.
Past 5 years before, we have had a meeting wherein it was
Okay,
agreed that there
wait.
are-
Approach the authority
Your
personally,
lordship,
my lord.
At that time itself, we have submitted a bill to a tune of 4.5 crores, your lordship.
Okay.
That amount has not been, till now it has not been disposed, your lordship. Your lordship, there are more than 250 workers, Arunachal Pradesh, local workers. Your lordship, we have not paid even a single rupee to them. Your lordship, here.
My lord,
Okay.
his partner is executing, and if there's any dispute, they
Uh,
should resolve it,
I
my lord.
s-
My
I
lord,
dispose of the instant writ
my lord,
petition.
regarding,
Let us see your representations which you had made to the
Yes,
department.
yes, your lordship. There-
Where? How many? from annexure,
Here I have filed only 5 to 6, your lordship.
5
But
to
in the,
6.
yes, your lordship.
The latest being dated
8/7/2024, your lordship. For that also we have not,
annexure.
page number 56, your lordship.
So we can dispose of the instant writ petition.
Yes, your lordship.
Giving a direction to
Yes,
the
yes. Respondent.
state respondents
Yes, Your
to consider the representations
Yes.
or letters
Yes, your lordship.
which has been submitted and enclosed in the writ petition, and accordingly we can dispose of the instant writ petition, isn't it?
Yes, yes.
Because concerning the money, there's already a
Yes,
money
yes.
suit. What is the money suit? Have you mentioned the name in which court?
Senior,
Numbered as,
civil judge, senior division. UPR.
Okay,
40, Your
UPR.
lordship.
Huh? Fine. Heard Mr.
Muhammad Wasiuddin.
Wasiuddin, learned counsel for the petitioner, along with Mr.
Tabatagum.
Tagan, learned standing counsel for
Health Department.
the health department. The learned counsel for the petitioner submits that the instant writ petition is filed for the reason that the petitioner and the private respondent number 5 had made an agreement that to operate a joint account by MS Kenge Construction Company, within brackets respondent number 5, and B4B IT Solutions Private Limited. And that the works, what is the work which you were supposed to do? You were given some work, isn't it?
Yes, lordship. IMSS.
Wherein both the petitioner and respondent number 5 deal with IT software and infrastructure products and services. The petitioner and respondent number 5 had then entered a gem tender, is it dated 03/02/2022 for selection of system
Yes, your lordship.
for implementation of IHMIS-Arunachal Pradesh called by the National Rural Health Mission, Arunachal Pradesh. The petitioner and respondent number 5 successfully bid for tender and was awarded the bid dated 03/02/2022. In the agreement, the petitioner company has a stakeholding of 91%,
49, your lordship.
41%, while the respondent number 5 has 51%. Thereafter, the mission director, National Health Mission, Naharlugun, credited the funds amounting to how much?
60.14.
60.13 crores into the escrow account.
Not escrow, only KCC account.
Okay, into the, okay, where's the,
Respondent number 5.
into the account of respondent
Respondent
number 5.
Yes.
Okay, which is not as per the agreement made by the petitioner and respondent number 5, wherein the said amount was to be credited to the joint account of both the petitioner and respondent number 5. And so, the learned counsel for the petitioner submits that with regards to the deposit of the said amount into the account of respondent number 5, the petitioners have filed a money suit before the senior civil judge, Pasigat,
No, UPIA, madam.
UPIA, in money suit number
40 of 24.
40 of 2024. Full stop. The learned counsel for the petitioner submits that the instant case, the instant writ petition, okay, is with regards to the apprehension of the petitioner that the future deposit of the remaining amount of rupees,
Will be around 40 crores.
approximately 42 crores,
Yes, Your
would again be deposited into the account of respondent number 5.
That, my lord, one just, that amount exactly figure that we cannot figure out right now because,
Approximate amount.
well,
So we have mentioned approximate amount, okay, remaining approximate amount of 42 crores would be again deposited into the account of respondent number 5, which is not as per the agreement made between the petitioner and respondent number 5 and the petitioner and the respondents.
Yes, Your
Okay. Dated, what is the date of that agreement?
It is contract 29th.
Annexure number?
3 years.
Okay.
Page number.
Just a minute.
Dated 25th February, is it 2022?
25th February 2020.
Yes.
Your Lordship. Election number 3.
25th February
Yes, Your Lordship.
2022. Okay. Full stop. The learned counsel for the petitioner further submits that the petitioners had been making representations to the respondents, informing them that in terms of the agreement made between the petitioner and the respondent number 5, in terms of the said agreement, okay, the no money with regards to the contract should be deposited into the account of respondent number 5. However, receiving no response, they have filed the instant writ petition. Then, Mr. So-and-so, learned counsel for, learned standing counsel for respondents number 1 to 4 submits that the reason why the said amount of so-and-so, okay, was deposited into the account of respondent number 5 was due to the fact that there was no what GST.
No GST registration in respect of this joint venture with Kenge and IT solution.
There was
The
no
other,
GST registration in respect of the joint adventure made between,
Kenge Construction and 4B IT solution.
okay, both of them.
Yes,
Okay,
yes.
Kangar Construction.
And joint
That
PAN
is
card,
respondent number 5 and the so what was the petitioner.
as well as joint PAN card. madam. PAN
As
card
well
in the
as
name of this
The
joint venture.
partner,
PAN card.
PAN card,
And-
permanent account.
and that there is no PAN card with regards to the joint account,
Yes,
the joint account.
This confirmation.
Huh.
Joint account was opened, Your Lordship.
PAN
No
card,
PAN
but
card,
there's no PAN card, no
Yes, Your Lordship.
GST registration, and as a result, madam, there's a problem in the billing. We cannot process the bill unless there's GST. and-
Because of this, there was a problem in depositing the say,
Processing the bill, madam, processing the bill.
processing the deal into the joint account of the petitioner and respondent number 5.
And what department has available is the PAN card and GST of the one of his partner, that is Kenge Construction. That's why we have.
Because of this, the respondents number 1 to 4 had to deposit the said amount into the account. of
Respondent number 5?
respondent Number 5.
As a partner of
Being
the
partner
petitioner.
of the petitioner.
Yes.
Having heard the submissions made by the learned counsels for both the parties, this court finds that the instant writ petition can be disposed of with a direction that the respondent number 1 to 4 should look into should consider the representations made by the petitioner number 1, and that the petitioner number 1, along with the respondent number 5, should also look into the difficulty faced by respondent number 1 to 4 to comply with the said contract agreement dated 25 February 2022. Within a period of, that's where 30 days?
30 days, ma'am.
30 days from the date of receiving the certified copy of the said order. Okay, accordingly, WPC number 304 of 2024 stands disposed of as above.
Deeply obliged.
My lord, what happened in this writ petition, my lord?
Hmm.
My lord, the petitioner has participated in NIT. And my lord, after evaluation of the bids, my lord,
Yes.
petitioner has been recommended by the Technical Evaluation Committee for awarding of the contract, my lord. Thereafter, my lord, on the approval of the competent authority, my lord, letter of acceptance was issued to the petitioner, my lord. And
So wait, before you proceed,
yes,
this court's order, last order.
yes, my lord.
You
There
have
is,
prayed for time.
yes, my lord.
File a affidavit in reply.
Yes, I have prayed for
So have
time.
you filed?
Not yet, my lord.
Then
And my lord,
file your the affidavit in reply first. I think it's regarding the receipt of the letter of acceptance.
yes, my lord.
So what happened?
submission
Someone
of-
else has received on your behalf.
No, yes, my lord. That letter of acceptance is received by someone else, my lord.
So have you
Not by me,
contacted that someone else?
Yes, my lord.
Have you contacted that someone else? You said that someone else, not me,
Yes,
has received the letter of
Yes, ma'am.
acceptance. So have you made an effort to contact that person and find out what is going on? It's a very simple matter, it appears.
yes, my lord. My lord, after a lapse of 7 years, 7 days, my lord, I'm sorry, my lord, 7 days. But in
Days.
in letter of acceptance, 7 days time is given to me to submit the performance guarantee, my lord.
Okay, so what about this letter of acceptance? Have you found out what happened?
Now,
Was
my
it
lord,
sent to you?
now, my lord, it is came to my knowledge, my lord, and I'm ready to give my performance guarantee, my lord. But they are denying, my lord, now, because this 7 days time is already lapsed, my lord.
Hmm. So what
My lord-
about the government advocate?
Yes, my lord.
For the
On last
respondent?
occasion, my lord, as the senior government has been directed to take instruction, my lord, whether
Yes,
they can accept my letter as a performance guarantee now.
with some penalty. He
Yes,
has
ma'am.
mentioned letter of acceptance by allowing him to furnish the performance guarantee with penalty.
Lord.
So have you received
Yeah, Lordship,
instructions?
the tender has been already cancelled, Lordship. And
Oh, so fresh tender.
no,
Not
they
yet.
have
Has been
decided,
issued?
they
Not
have
yet.
decided, not yet issued, Lordship.
Oh.
They have decided to go for the press tender also. Since the tender has been already cancelled, Lordship. And the authority, I have discussed with them, and after discussion, Lordship, they came to conclusion that the matter may be decided as per the merit also.
Okay.
My lord, in that case, I will
Then
find,
you have to find your reply affidavit,
yes, ma'am, within
most
1
probably.
within
Uh,
1.
Otherwise,
Yes.
if the government was a little bit more lenient, this matter could have been settled, let him pay with some cost and finished off.
Yes, ma'am.
Because his, this thing was already accepted.
Oh.
Only thing is he didn't receive the letter of acceptance in time.
Yes.
Isn't it?
He was
Anyways,
supposed to deposit the performance guarantee loss. And in
But
spite
he
of this,
didn't do that because he says he did not receive the letter of acceptance.
yes, the letter was served to his own lawsuit brother lawsuit in his own resident lawsuit.
Anyways. uh-huh.
Anyway,
So you find your, this thing, reply affidavit then heard, Mr.
H. Lampu.
H. Nat, learned counsel for the petitioner, along with Mr. Tapping, learned government advocate. Good. Learned senior government advocate for the respondents. The learned counsel for the petitioner has prayed for further time to file his affidavit in reply. In view of the above, list after
1 week, 1 week, ma'am.
list after 1 week.
Obliged, deep loss.
Yes, what is stage?
Yes, my lord. This is in the motion stage, my lord. Now, my lord, what happened, my lord? I am the primary teacher, my lord. Now presently posted at Daporijo as a coordinator, my lord, in the office of the DDSC Upper Sulawesi District, my lord. Now, what happened, my lord? In the ensuing, my lord, the recent state assembly election 2024, my lord, I was asked by the private respondent, who is the MLA of Dumpurijo, my lord, asking me to support him and campaign for his election, my lord. Now, I politely refused because I am a government employee, my lord. Now, what happened in Revengeful Act, my lord, he initiated my transfer posting, my lord, before election, my lord. Now, he could not materialize it because due to the enforce of election code of conduct, my lord. Now, what happened after election, my lord? Now, what has to be seen, my lord? I am posted at Daporijo, which is a separate constituency, my lord. It is 24 ST Assembly constituency. Now, this private respondent, he is from 26 Dumpurijo ST Assembly constituency, my lord. Now, since I am posted at Daporijo, my lord, I am not within his jurisdiction, my lord. Now, what happened, my lord? Out of my revenge, my lord, he initiated, my lord, one note, my lord. My lord, may I please count page 27, my lord.
So you're challenging the transfer order, saying that it is based on
Only on political consideration.
written by the MLA.
Yes, my lord.
Page,
27, my lord.
it's there, a letter written by the MLA.
Yes, my lord.
What
But-
does it say? Where?
Last page, last serial number, last, my lord. Takarapuk, my lord, PRT. My lord, type copy is at page 28, my lord.
Okay.
28, I would, relevant would be at page 29. Serial number 21, my lord, Takarapuk, sir. Coordinator DDSC office to Changlang district, my lord. Now, my lord, basing on the same, my lord, this recommendation of the private respondent, my lord, I have been transferred. Page 31, my lord, impugn order. Impugn transfer posting order. My lord, may please come to page 32. That would be serial number 42, my lord. PRT coordinator DDSC office Daporijo at the
But
disposal of the
along
DDC.
Along with you.
Many
there are
others were
many persons who were transferred.
Yes, ma'am.
So.
They are
you're
coming,
saying
my
that
lord.
all these people have been transferred because of a letter from an.
Yes, yes, my lord. Yes, my lord. They are also coming, my lord.
We'll have to see.
My lord, in my case, my lord, how, my lord, see the note, my lord.
How?
Serial number 21 and the transfer posting order, my lord.
Because-
It is the replica of the, my lord, this recommendation, my lord. And this has been accepted by the, my lord, private respondent in the social media also.
Yeah, also some other grounds, maybe.
No,
it's
my lord,
not
this is
only
only the,
that.
my lord
You
may
look
see
at
Annex 3, my lord.
Uh-huh.
Annex 3 is very simple, my lord. I have to be posted from coordinator DDSC office to Changlang district, my lord. Page 27, my lord. This is the note list prepared by the private respondent.
Okay, what about the respondents? Do they have some transfer policy, something based on which you all are transferred, anything? I think that you'll have to look into,
My lord.
because these are all transferable posts, isn't it?
Transferable post, but not on the political constitution, my lord. It has to be, the respondent authority has to apply their mind, my lord. My lord may see the recommendation, my lord. Exact replica order has been passed, my lord. My lord, in this case also, my lord, in another case, my lord, Mr. Tagu, my lord, was the petitioner, my lord, and I was the respondent, my lord. That is stay granted by this honorable court, my lord, on political consideration, my lord.
My lord,
What?
my lord, that is,
Same matter, covered?
no,
No,
that
my lord, this is a
different-
transfer posting
totally
matter.
different matter. That
Transfer
was-
posting matter, but on a
I-
political consideration, my lord.
I brought on, here is the case, my lord, everything material, it is reflected in the order and there's no independent decision on part of the authority. That was different aspect.
Issue notice and.
Well,
let's
in
see
this,
then.
in that case, my writ petition would become infructuous, my lord.
Why?
Because my lord, I have been transferred, I have to leave, my lord, in that case. My lord. So at
So-
least for deciding the issue, my lord, my lord may kindly stay the impugned order. Or otherwise, on the next week, my lord, this matter
Now,
will
how
discuss.
many persons in this order, from this order has filed a writ petition? Any other person in
My
the
lord-
serial number? Because I can see that.
I am the first
other-
person, my lord.
You're the first person.
yes.
Anyone else?
Serial number 7 also same manner. Serial is also serial number 7, act numbers, the cause list number 7 manner. It's also one manner. It's connected to this.
Connected, same.
Yes.
You see, because supposing we stay this transfer order, then it will invite all the other names in this order to also approach this court.
My lord, may kindly
Obviously,
not
my lord.
consider that issue, my lord, because this, the legal issue, my lord. No, transfer posting are totally administrative in nature, my lord. Why this political consideration, my lord? Because I have not voted for, I have not campaigned for him, my lord.
Okay, what's this? You're saying that this is covered by a judgment?
Covered, my lord.
WPC.
He is in the benefit of interim order in one another case, my lord. This is, my lord, page 3, my lord.
Page
Page 3.
3.
Yes, my lord.
Ah,
This court has also seen the UO note, my lord. UO note, my lord, is the same, my lord. This is the note prepared by the private respondent in my case, my lord.
this is an, made
Interim
by
order.
the, okay, let's see the interim part.
And this is the one case which was disposed, my lord, by Justice Kardak, my lord, by this honorable court, my lord. Page, my lord, page 9, my lord.
Hmm.
Page, para 20, my lord.
Okay, what are the facts here? Transfer
Same, my
order
lord. Yes, my lord.
based on the letter written by
The minister, my lord.
minister.
Yes, my lord. Para 20, 21, 22, my lord. 24, my lord. My lord, may see page, para 23, my lord. This code is not of,
Yes. Read.
my lord, sorry, my lord, para 20, first, para 20, my lord. I may profitably, my lord.
Hmm.
I may profitably refer to the case of so and so, Pralok Chand, my lord. That's all. In the system of Indian democratic governance as contemplated by the Constitution, senior officers occupying key positions such as secretaries are not supposed to mortgage their own discretion, volition and decision-making authority and be prepared to give way or being pushed back or pressed ahead at the behest of politicians for carrying out commands having no sanctity in law. Para 21, my lord. The plea of non-impleasement of minister as party respondent for alleging malafide raised by the Learned Counsel for the State is considered only for rejection as in considered view of this court is not a case alleged malafide against any particular person so as to contend that such malafide exercise of power is the foundation. The impugned order has been issued at the behest of minister on extraneous consideration and the respondent authority has succumbed to the dictates of the minister and only on his desire the impugned transfer order has been passed to accommodate the respondent number 3. Without any administrative exigency and public interest, which is evidently a colorable exercise of power. In my considered view, on the facts admitted in the present case, the minister is not a necessary party in such a case. It is not the case of raising some disputed question of fact alleging malafide on the part of the minister requiring his presence to answer the same. In the present case, as noted above, the respondent authority appears to have mortgaged the decision-making authority by yielding to the recommendation made by the honorable minister so as to accommodate the private respondent in place of the petitioner without being any discernible administrative exigency, public interest. Para 24, In view of the discussions above herein, this court is of the considered opinion that impugned order dated so and so issued by the secretary so and so transferring the petitioner from 02 to Jengking by bringing the respondent number 3 in place of the petitioner is not sustainable in law. Accordingly, the impugned order dated so and so issued by so and so is hereby set aside. My lord, what I say, my lord, I have a prima facie case, my lord. And balance of convenience is also in my favor. So I may be protected, my lord.
Anyway, you will issue notice first. Heard Mr.
BP Chauhan.
B. Picha, learned counsel for the petitioner, who has filed the instant writ petition challenging the transfer and posting order dated 1909.
Yes, my lord. This is also, there is also difficulty. 1909, my lord, please again come to.
2024, is it this order?
Yes, 1909, page 31, 19/9/2024,
Oh,
page 33, my lord. Sign on 10/10/2024, page 33, my lord. Continuation, this is the continuation, my lord. Page 31 is the impugned order.
31 is the order.
Yes, my lord. Issued on
19
10/10.
September 2024.
Yes, my lord.
And where?
And issued on 10/10/24, page 33, my lord.
Bottom, last bottom.
Last bottom.
Okay.
Corner, yes.
Anyways, so you can explain all this.
Yes, yes, ma'am.
Dated 19 September 2024. The learned counsel submits that the said transfer order was made without any application on mind and based purely on political consideration. So he therefore submits that the said transfer order of the petitioner is liable to be set aside. In support of his submission, the learned counsel has relied on the decision of the coordinate bench of this court in WPC/359/2024 dated 28/08/2024 and WPC 467/2023 dated 22/11/2023. The learned counsel for the petitioner has also prayed that the instant impugned transfer order with regards to the petitioner may be stayed till the disposal of the said writ petition. Issue notice to the respondents, Mr. So-and-so, learned standing counsel for education
Yes, ma'am.
department accepts notice on behalf of the state respondents. No need to issue formal notice. Requisite copies of the petition to be duly furnished to the learned standing counsel.
Private respondent 6 is there.
Pardon?
Private respondent number 6, my lord.
Okay, a notice be issued to register posts with AD within 3 days, returnable by 3 weeks, as well as through usual process to the private respondent number 6.
Madam.
List after 3 weeks. In the meantime, considering the nature of the said writ petition, this court find it fit to stay the impugned transfer order dated so-and-so. Okay, with respect to the said petitioner till the next date of listing.
Madam, in respect of petitioner, madam.
Said,
My lord, instead of 6 weeks, let it be 3 weeks, my lord.
It has been started 3 weeks.
3 weeks,
three-
I've
okay.
mentioned 3 weeks.
Much obliged.
Yes. I think it's more or less the same. Is it?
But item number 4, my lord, I think. Item number 4.
Yes.
My lord, this matter is pertain to non-publication of my lord advertisement in the newspaper, my lord.
No newspaper advertisement
Yes, my lord.
regarding what?
Regarding my lord appointment to the post of annexure number, my lord, annexure Two, my lord, page number 24, my lord.
Page number
Page number 24.
24. This is an advertisement.
Yes, my lord. My lord, respondent authority issued an advertisement on first of this month, my lord.
Oh.
Inviting application from the particular subdivision, that is additional.
So advertisement has been made. So what's wrong?
My lord, this advertisement was not
See,
wide.
copy to DC administrator, then DI department, this is what DIPRO for wild publicity and publication in the local daily. Copy's been given.
My
Page
lord,
25.
my lord, what my lord, for petitioner have, my lord, searched all the my lord, paper publications, which has been published after this very advertisement, my lord. But petitioners unable to find any newspaper publications pertain to this very notification, my lord. That is the contention, my lord.
Yes, respondents, because here in the advertisement, it should be for wild publicity and publication in the local daily.
Lordship, we'll
So
see
any
that.
publication done or no publication?
Lordship, this is basically within subdivision only, and this is contingency post, not sanction post. Lordship will see skill and skill. This is 10,000 and 12,000 and 13,000 only. This is not sanction post.
It is not against a sanction post or
Yes.
whatever, but walk-in interview, etc. No, look at page 25.
Yes.
Here, it says that this has to be given wild publicity and publication in the local daily, isn't it, the advertisement?
Daporejo.
So he says that this did not happen.
Lordship, in that case, I will take instruction. Otherwise,
Instructions
Lordship
whether it was required or not, isn't it? So we should notice. first.
doesn't have any
Meantime, my
choice, Lordship.
Meantime,
Otherwise,
my lord, this result maybe
no.
state, my
No,
lord.
no. We cannot say the result, but it will be subject to the outcome of.
Because,
this
my lord, in the
petition.
meantime, if
Yes.
in meantime, if the private respondent were appointed, my lord, then in that case, my matter will become infectious, my lord.
No, Lordship.
Because, my lord is well aware, because, my lord, any advertisement has to be
But the.
published in the
See, the
newspaper,
submission
madam.
made by the learned government advocate is looking at the nature of the job, which is not a sanction.
Temporary, Lordship, engagement only. These
My
are
lord,
managed for
My
office
lord, from my
management.
understanding, my lord, any government
Anyways,
job, my lord, whether it is temporary or permanent, it has to be widely published in the in the newspaper, my lord.
whether widely published or not, that's a different matter, but if we look at page 25, here, there's an instruction that it
Yes,
has to
this
be
much I will take
for wild
instruction.
publicity.
This is, my lord, it is,
So
yes,
because of that, you get instructions whether any wild publicity was given, and if not, as to the reason. They'll have
Yes,
to
Lord.
answer to that
That I
issue.
will.
Yes.
my lord, in that case,
Heard
sort
Mr.
that may be
Yes,
given.
heard Mr.
El Kurdu, my lord.
So learned counsel for the petitioner who has filed the instant writ petition.
And Lordship, I will be for 1, 2, and 3.
Challenging the legality of the advertisement dated 01/10/2024 issued by the additional deputy commissioner, Kodak, Upper Subansiri district, Arunachal, on the grounds that there was no publication in the local newspaper wherein the petitioner was not given the opportunity to apply, to respond to the said advertisement.
Lordship, just a second. Lordship, it is clear from the advertisement that the PRC, of the petitioner or whoever may be from the Kodak subdivision only. This is for that particular place.
So he's not from the subdivision.
My lord,
Yes.
I have annexed,
Let's say.
my lord,
let's
and I have annexed all my document
Okay.
that I am belong to this very particular
Huh.
subdivision, madam.
And wherein the private respondents number 4 to 7 were recommended against the circle officer office jarring, upper Sabansiri district, Arunachal Pradesh. As skilled and unskilled contingency, is it? In which department?
In, my lord, it is a department circle officer jarring against the circle officer jarring.
Okay. Unskilled, full stop, okay, the last is this. Notice be issued to the respondents. Miss so-and-so
Ji Atra,
accepts notice on behalf of state
Respondent.
respondents number
1 to 3.
1 to 3. Notice be issued to registered post with AD within 3 days as well as through usual process to the private respondents number 4 to
4
7.
to 7.
Returnable by 3 weeks. List after 3 weeks.
My lord, because madam, my lord, there is urgency is there because board has already recommended and it is supposed to be appointed anytime, my lord. So, my lord, in the meantime, if government council is directed to seek direction for the authority if the paper publication was done or not, because if paper publication is done, my lord, then I have no case, my lord.
Okay, then we'll
So,
make it.
short time I fix.
I will take instruction only, Lordship.
Yeah,
then.
Yes,
just after 2 weeks in the meantime.
1 week, my lord.
1 week.
Yes, my lord.
Lordship,
In the
since
The one-
meantime, the learned government advocate is to get instructions from the state
official
respondents,
respondent, Lordship.
from the state respondents, whether the newspaper publication was done in terms of the advertisement dated 1st October 2024. Yes, list after 1 week.
Lordship, let it be on 30th.
Okay, list after, will it be after 1 week on?
Yes, 1 week.
30, 10.
Yes.
2024.
Obliged.
Obliged.
Yes,
May I please, your lordship? Lordship, I am being aggrieved by the action of the DDAC, SEPA, whereby the petitioner has been already transferred and he is not releasing me from the establishment, lordship. That's
where
the
is
whole,
the transfer order?
lordship, page 10 is the transfer order. Lordship will, page 10, annexure 1.
Then you are a
I'm
teacher,
at serial
trained
number
graduate
6.
Teacher.
Lordship, I am at serial 6, lordship. Miss
And
Mum-
you were transferred to Itanagar
Yes. And
from Kaming district.
lordship, may kindly see serial number 7 also, lordship.
Hmm.
Serial number 7 is the reliever, lordship. The first move has to be from my side, lordship. Once I move out from that place, the reliever will move out from
Hmm.
the another school where I am supposed to join, lordship.
So then the respondent, who's the respondent? Yes, you're not releasing her, why?
My lord, I don't know, my lord, there's, it seems some communication gaps there. Anyway, my lord, the DDS may be directed to release her within 15 days that we can, otherwise,
It's as simple, we can
Well,
dispose of.
yes, my lord, it can be disposed of.
Okay, heard, Mr.
JGD, lordship.
J. Ginny, Learned Counsel for the petitioners, who submits that the instant writ petition has been filed on the grounds that the petitioner, who is a government,
TGT, lordship.
Trained graduate teacher.
okay, who is a trained graduate teacher under the government
Government of Arunachal Pradesh.
of Arunachal
Education Department.
Education Department, has been transferred by the transfer order.
Dated
dated-
13 August.
Where's the page? Just take me.
10, page number 10.
Okay, dated 13th August 2024.
Signed on 11/9/2024, Lordship.
It's okay.
All
with
right.
The date, okay,
All right.
13/8/2024. However, in spite of the issuance of the transfer order, the respondents have not issued her release order, which is causing great inconvenience to the said petitioner. Mr. So-and-so, appearing on behalf of the respondent, submits that the release order appear not to have been issued because of some communication gap, and submits that steps will be taken by the respondents to issue the release order, since the petitioner has already been transferred from GSS, Pakoti, East Kamen District to GSS, P dash Sector Itanagar, ICR. In the letter dated, in the order, dated 13th August 2024. Having heard the submissions, wait, before I go ahead, there is this release order. What is this?
That release order is from the headmaster, Lordship.
Concerned school, madam.
Since
Okay.
DDSC is the controlling officer,
Okay, so
it has to come from him.
in his submission, has the respondents have failed to issue the release order, while the release order was issued by the concerned headmaster, government sect school, Pakoti, East Command District, by his letter dated 24. Is it, what's the date?
Madam,
29.
29.
2024. Then let's go back. Having heard the submissions made by the learned counsels for both the parties, this court finds it fit to dispose of the instant writ petition with a direction to the respondents to issue the release order
Particular respondent number 3, madam. 3.
for the instant, particularly respondent number 3.
Deputy Director of
Okay,
School
wait,
Education.
respondent number 3. In view of the fact that the petitioner has been transferred from, again, so-and-so to so-and-so by the order dated so-and-so. Within a period of
15 days, madam.
15 days from the date of receiving a certified copy of this order. Accordingly, WPC 461 of 2024 stands disposed of as above.
Watch out, Deputy.
Yes.
Number 6.
What is this matter about?
Yes, my lord, this is regarding the tender. I am a second class contractor registered under the PWD Arunachal Pradesh Department. And respondent authorities have issued a notice inviting tender on 3rd July 2024. Accordingly, I have, my lord, participated in the said tender for construction of road from Afar Liak to Bebe Colony, that is in the district of East Kamen, Arunachal Pradesh. And first, I have challenged by filing this writ petition. I am seeking to challenge the first bid evaluation report, part 1, and the subsequent inter process, because it had been done arbitrarily, whimsically, without following any the procedure established or under the SBD. Your Honor, the first evaluation report is at my lord, it is in page 49.
See, before you go ahead in your writ petition, page 7, page 8. You have said that your representation has not been considered. Non-consideration of your representation dated 13/08/2024. And then on page 8, for non-consideration of your representation dated 25/05/2024.
Yes,
Wherein you have complained
yes, madam.
against the MS Capital Enterprise, respondent number 7. Isn't it?
Yes, yes, madam. On 13 August,
So what happens to your representation? It's still not considered?
not considered, they are sitting over the representation, no
Can we
response.
dispose of the instant writ petition with a direction that the respondents should consider the representation with a speaking order? Can we dispose it off like that? Because your representation is still pending.
Yeah, yes, madam.
Then let them respond to your representation, and if you're unhappy with the way they have responded to your representation, then maybe you'll have a case, because it's still pending. This, it's not been considered yet. It could be, what, considered in a positive way also,
Yes, yes.
isn't it?
My lord, this representation was submitted by one,
Uh,
uh,
there's a pending representation, it appears.
Liak, not
Hmm.
the petitioner himself.
Oh.
No,
Now,
Uh,
this representation dated 25/9/24, it speaks something. The representative of the petitioner have some personal grudge with the proprietor of the successful bidders. They have so many allegations that she married to non-APSCT, she should not have possessed the
okay,
license.
so you have considered his representation, is it? Have you looked into it? Have you replied to his representation?
No, that-
But the petitioner has not made any representation, is it? Have you made?
yes. This-
Where?
this,
Where's the
This
representation?
earlier, he is the attorney holder. This is power of attorney holder. At last page 236, my lord. 236 and 37 is the power of attorney.
236.
Yes, yes, last page. 236.
Huh.
So he is the legal representative of the.
Okay, so
oh,
power of attorney has been executed.
Yes,
This petition is filed by the proprietor himself.
no,
So the representation was filed by someone else based on the power of
No,
attorney.
no, ma'am,
is it?
not like
Then
that.
what?
it is the attorney
Yes, a
holder.
power of attorney.
Oh, yes, on behalf of this principal only, it has representation has been submitted. That is purely regarding the evaluation report.
Okay, so what do? We cannot dispose it of at this stage. Will issue notice?
I have no issue.
No, will issue
If
notice,
that
then
is-
I was thinking it'll be easier for you
Yes,
if we just pass an order to look into consider your representation.
yes, yes.
My lord, otherwise at this stage, the man and machine already started the execution of the work.
Okay, then then we'll have
No,
issue notice.
my lord, there is a prima facie on the apparent on the page of report, there is a prima facie arbitrary action on the part of the authorities. Because my lord may say, first evaluation report,
Page?
page 49. 49 and 50. 50, they have cited the ground for the rejection of my technical bid. That is the first part. JJ, this item serial number, I am at serial number 3. Non-responsive, I have been declared as non-responsive because it attracts SBD clause 4B, 4.4 capital B, small v.
Page 50.
Yes, page
Okay.
50, my lord. Page 50, this is serial number 3. This is JJ interface.
Okay, we'll issue notice because you're saying that this finding non-responsive is not correct because you have responded.
authorities have stated that I have not submitted all the documents. And now I have submitted all the documents before this honorable court, what I have uploaded online. On the, just, there is no reason, Your Honor, my lordship, that I should be rejected or I have to be declared non-responsive.
Okay, will you show notice? Mr. So learned counsel for the petitioner
And Gabu.
who has filed the instant writ petition for quashing the approval and acceptance letter dated 20/08/2024, whereby the respondent authority has approved the name of respondent number 7 for awarding the work care of road from, within inverted commas, L021 dash Upper Liak to Baby Camp, comma, package number AR/03/01/080, close inverted commas. Despite the several defects in their bids, and had rejected the present petitioner on the grounds that the petitioner had not responded
My lord, for their ground is not furnishing the list of machineries and laboratory equipments, that which I have already approved.
not responded and attracted SBD clause 4.4b between brackets small b, comma 4.4b between brackets small b, close bracket, then open bracket 2 small 2i, a close bracket, and 4.7 between brackets 1 small I. Okay. In the letter dated 2nd August 2024. The learned counsel further submits that the petitioner had submitted many representations to the respondents, which has not been addressed to till date. In view of the above, the petitioner is
My lord,
compelled to file
my
the
lord.
extent writ petition.
Since there is prima facie this arbitrary action on the part of the respondent authorities. So even the work started, it should be stayed.
Compelled to file the instant writ petition due to the arbitrary action of the state respondents. Issue notice to the respondents, again, through registered respondents, Mr. So-and-so.
I'm appearing 1 to 5.
Accepts notice on behalf of respondents number 1 to 5. Notice be issued to the private respondents 6 and 7 through registered post with AD within 3 days, returnable by 3 weeks, as well as through usual process. Okay, list after 3 weeks. Requisite copies of the instant writ petition to be duly furnished to the learned counsel for respondents number 1 to 5. Then anything else? List after 3 weeks.
I have served a copy to cabinet also, my lord.
Already served.
In the meantime, in the interim, since
Already started.
The prayer for interim order will be considered in the next day of listing. Yes, because the work has already started, so it's been, will be considered in the next date.
Obviously.
obligation.
Yes.
My lord, this matter is analogous matter with item number 3, my lord.
Pardon?
This matter is analogous to item number 3, wherein my lord has stayed the transfer order.
Oh, the transfer.
Yes,
Same
madam.
order, is it?
My lord, same order, my lord.
Okay, so we can pass similar order as the one which we passed in item number 3.
3, my lord.
Only thing is the instant petition is serial number what? In
Serial
the
number 17,
impugned
madam.
order.
17.
Same order.
Deeply obliged.
Yes.
My lord, that challenging the impugned transfer and posting order, my lord. There is a small, only a small question of law, my lord. Transfer and posting is an incidence of service. Government employee cannot insist that he or she should be posted in a particular place, my lord. If he or she don't comply with the transfer order of the government, my lord, law is well settled that disciplinary action can be initiated, my lord. That is. Now here the question is, my lord, I am not quarreling on or per se, my lord, not agitating on the tenure. I have completed the tenure, I have overstayed. But the issue, my lord, the short issue involved in this writ petition, my lord. No, you wait, just you wait. No, you take your own time.
Wait. Let's see
Don't
what
do
does
that.
he want before the concerning the merits. So what do you want?
Actually, I just want to inform that the here petitioner is already handed over the charges, etc. He is already released.
No, that is another thing. You just take your
You
own
have
time.
been released.
Yes.
Anyways, go ahead.
Yes. Take your own time, do your cases.
Yes.
Now, my lord, what happens is the short question that is involved. There is a judgment by the coordinate bench of this honorable court in the form of Hibutama, my lord. Here, the petitioner is a regular executive engineer, my lord. And the respondent is an assistant engineer. And his substantive post is an assistant engineer, and he has been allowed to function as an in-charge executive engineer in his own scale of pay, my lord. So now the question is whether this order is good or bad. But the reality remains, my lord, that the coordinate bench of this honorable court has held on the status of the person. It says there cannot, my lord, be an interstate transfer between a regular employee with the junior officer, my lord. So that particular law is there, my lord. So on this basis, this entire writ petition has been structured. My lord. So, my lord, for this, kindly see the impugned order, my lord, at page 24. Page 24, my lord.
24 of
My writ petition, my lord.
not the IA. The IA has been
No, IA, my lord, that interim order was modified.
okay.
Today,
So it's no longer the IA.
I am not filing anything on that.
Okay. Page
Page 24, my lord.
24.
Yes. This is order dated 3rd September 2024. my lord. I stands at serial number 3, my lord. I am Tara Hache, my lord. I am transferred. I was executive engineer Sapa division under urban development, my lord. Then my reliever is, my lord, Vice Engineer Helan Taju, executive engineer, in charge transferred, my lord. My lord will mark this distinction, my lord. Then what had happened was, my lord, the German of entire matter starts from page 25, my lord. My lord will kindly come page 25, that is annexure 2. This is initiated. My lord, that Mahmoud Masud judgment, I think we need not to deal with this. But then just I want to establish my case that the German of the entire transfer and posting has been initiated by this UO note by the Honorable Minister. Only to show that there is a mala fide behind. my lord, in transfer and posting matter, my lord, as I have clearly submitted that employee cannot agitate, I should be posted or remain in a particular place, my lord. So that apart. And then the Mahmood Masood judgment also very clear that the politician has been an elected representative of that particular district or the constituency has a power to write. But that must be based on a reasonable public policy, my lord, not otherwise. So then this is only to establish, my lord, to that count. Now, my lord will kindly come to Annexure 3, page 26, my lord. Here, my lord, I am going to show for one particular purpose. If my lord may kindly allow me to read this, para 5 of my
Para 5 of your writ petition.
my rate petition.
Wait, just a second.
That the petitioner begs to state and submit that the respondent number 3, who was serving as assistant engineer, my lord will mark this. That the petitioner begs to state and submit that the respondent number 3, who was serving as assistant engineer CCD and was posted on 22/3/2023 wide so and so, wherein specifically mentioned as his substantive post as assistant engineer CCD on his own pay scale. In the aforesaid order dated 22/3/2023, it is reflected that the appointment of respondent number 3 is in charge, assistant engineer, and prior to that, his substantial post is assistant engineer. So, my lord, I am making it for only to differentiate that the petitioner is a regular executive engineer and the respondent is a assistant engineer. So, two different cadre. Grade, my lord. Two different grade. I'll not say the cadre means the public health engineer, urban development, my lord, it comes. Now, my lord, kindly see, this is the sum and substance of my case. And there, my lord, if my lord will come to para 2,
Para 2 of your writ petition.
yes. My lord, here the ground has been set out, my lord. In the present writ petition, the petitioner is seeking a writ of certiorari in quashing and setting aside the impugned order dated. Sorry, my lord, am I first bit?
No, it's okay. Dated 19/9.
Yes. The 19/9/2024 white file number so and so issued by Commissioner Urban Affairs, whereby the representation dated 10/9/2024 has been disposed of and rejected without considering the ground, as in the representation and transfer order dated 039/2024 white so and so issued by the Commissioner Urban Affairs, Government of Arunachal Pradesh, Itanagar. Pursuant to the transfer order dated 039/2024, the petitioner is sought to be transferred from Sapa Division District to Raga Division, while District Kamle Wise Respondent number 3. The Respondent number 1 has issued the transfer order. The private respondent is in charge Executive Engineer Raga, District Kamle at his own scale of payment, and is only in charge as Executive Engineer whose substantial post is instead of substantial, is a substantive post. Sorry, the post is an assistant engineer, Urban Affairs. As such, he is not in the same cadre as of the petitioner, who is regular executive engineer. It is pertinent to mention that the respondent number 3, who is holding the post of assistant engineer, is not at all regular executive engineer as per rules, as impugned order dated 19/1/2024 and transfer order dated 039/2024 has been issued without application of mine for collateral purpose and on extraneous consideration, which nullify the intention without following the rules and regulation as set forth, as well as against the laws and guidelines framed for transfer and posting. The impugned order dated 19/9/2024 and transfer order dated 039/2024 has not been passed in public interest, but only to accommodate the private respondent number 3. Well, that is the reason why that annexure to the minister note, honorable minister note, was referred to. Although, my lord, that fortifies the argument of other side on the law laid down in the Mahmoud Masood case, my lord, by the Honorable Apex Court. Now, my lord will see, my lord will kindly have that Hibutama judgment. I think we last occasion we also.
What judgment?
Well, I will pardon. Yeah. Now, my lord has seen. Now, my lord has seen. In this case, my lord, I was for Renia Tamim, the respondent in this. Case.
Hibutama.
Yes, my
Is
lord.
it? What is the citation?
Just,
Oh, okay.
No, my lord,
2020, is it?
for GLT
For
503.
GLT, oh.
Yeah. My lord, in this case, my lord, I along with your brother Justice Ape, when he was senior additional AG, both of us were representing the government, and I was for the private respondent, my lord. The fact is, my lord, that Hibutama was a regular superintending engineer under WRD, and I was just officiating.
Okay.
But we are not similarly situated officers, my lord. So on the basis of that, my lord will kindly come to para 3 of the judgment for the facts.
So you're saying this is similar?
Yes, yes.
Oh.
Similarly situated. But 2 paragraphs, para 2 and 3 would be very important, my lord. This read petition under Article 226 of the Constitution of India is directed against the order dated 29/6/2020 issued by the Secretary RWD Government of Arunachal Pradesh, Itanagar, wide so and so, by which order the petitioner, who is superintending engineer working at Rural Work Circle, Pasigat, has been transferred and posted as senior surveyor
Wait,
of works.
you're reading from?
Para 2, my lord. Para 2.
Yes, okay, please continue. Continue.
Posted as senior surveyors of works in the office of the chief engineer, Rural Works Department, Eastern Zone, Itanagar, and and in his place, the respondent number 2, Mr. Renia Tamim, working as SSW Chief Engineer, Rural Works Department, Eastern Zone, Itanagar, has been posted as Superintending Engineer, Rural Works Circle, Pasigat. Also put to challenge is the order so and so dated 037/2020 issued by the Commissioner RW First Link Officer, whereby the representation submitted by the petitioner against his transfer had been rejected. The petitioner also seeks a direction to the respondent for disposal of the representation dated so and so on merit. Now, para 3 is important in our case. The fact leading to filing of the present read petition may briefly be stated as follows. It is case of the petitioner that while he was working as superintending engineer at WRC Pasigat, the process for transfer and posting of the respondent to started with an unofficial note being number so and so written by the member of the Parliament Lok Sabha Eastern Parliamentary Constituency Arunachal Pradesh in the following manner. My lord, that letter may be skipped, my lord. So now, my lord, kindly come. A series of Roman 2, my lord, a series of identical notes for posting of the respondent number 2 as SE RWC Pasigat follows, which were written by the honorable ministers and member legislative assembly UO notes dated so and so written by the minister so and so. Now, my lord, kindly come to 4 straight Roman 4. So all those we need not to read. Aggrieved by the posting of the respondent number 2 in his place at Pasigat, the petitioner submitted the representation to the Secretary, Rural Works Department, Government of Arunachal Pradesh on 30/6/2020, containing that transfer order dated 29/20 on the recommendation of Honorable Minister, members of Parliament and members of Legislative Assembly is a clear violation of government recommendation of transfer and posting shall be entertained by the government, and any recommendation in this regard in favor of the government employee shall be viewed adversely against the government official concerned. The petitioner further contended in his representation that 36 2020 that respondent number 2 is not a regular, my lord will mark this, is not a regular superintending engineer, but was only a functional SE, my lord. The fact fit into this judgment, my lord. Now, my lord will kindly come. My lord, I'll just request my lord to kindly come to para 62, the operation portion. Para 62 is the operating.
62.
Yes. My lord, here, my lord,
So it's a long judgment.
yeah, long judgment. Well, it took, my lord, 8 hours online. During COVID time, it was rendered.
This is a parallel. Yes.
Now, my lord, there is no quarrel with the proposition of law laid down by Honorable Supreme Court in Rajendra Singh Supra that it is not within the domain of High Court to enter into the relative interstate merit, conduct and integrity of the employees which are within the exclusive domain of the employer. That is, my lord, what I have fairly submitted. It is employer's domain, my lord. My lord will mark this. In the instant case, like in WPC number 257 AP 2016, the relative merit, compatibility, conduct and integrity of the petitioner vis-a-vis the respondent number 2 have not at all been examined by this court. Now, I'm also not beseeching my lord to examine the integrity merit here. What has been examined here is the position and status, my lord will mark. What has been examined here is the position and the status the petitioner and the respondent number 2 occupies in the department to find out the correctness of interstate transfer made. On examination of the position and status of the petitioner and the respondent number 2 in the department, it is found that the petitioner and the respondent number 2 are not similarly placed officers in the department. The petitioner enjoys the position and status, including pay and allowances attached to the superintending engineer, whereas the respondent allowed to look after the work of superintending engineer, SSW in the office of chief engineer, RWD Eastern Zone on purely temporary basis as a stopgap arrangement in the administrative exigencies of the department in his own scale of pay of executive engineer, which is substantive post of the respondent number 2. Now, similarly, my lord, as in the impugn order, my lord, which I have demonstrated a while ago, that the respondent is assistant engineer. For the administrative exigencies, well, the government has the power to do that. You have brought in. But, my lord, the law is well settled by this judgment that you cannot replace.
Intertransfer between.
There cannot be interest.
Okay.
So that is the only thing, my lord. So now only on this, even other side may say, I will file affidavit, I'll raise, but I'll not object to them, anything else. But my lord will only decide on this particular question. Because we are not similarly situated officers, my lord. That cannot be done at all, my lord. So therefore, my lord, this judgment, my lord, holds the field still today. Nobody has.
So you're saying that this is a covered matter in this judgment?
That's it.
Yes, okay.
They have filed the IA, my lord. In that IA also, something had happened that day, which I wish not to recall it, my lord. I was engaged in the morning. I received a brief at 12:30. A senior counsel from Guwahati comes, makes a submission. Then I also made a submission. My lord, just I have been engaged. I have just filed my power. And then I have not gone through the brief properly. But under 226 clause 3, my lord, once there is an IA for vacation of the interim order, in that even what happens is, my lord, practice and procedure which governs the field says that notice should be issued, the other party should be given adequate opportunity of being heard. Here, to file the reply and all, my lord. But that particular procedure was not maintained. But the IA, the Honorable Court, my lord, Honorable Court who
Disposed of the IA.
who,
Been
no, no, no,
disposed.
no.
Then
Who
what?
has granted the stay order again has suspended the order, my lord. Suspended the interim order in my favor.
Okay.
So that was vacated. So finally, I said, my lord, something. On the basis of that IA, my lord will have that IA number 180. And I'll just point out that particular point.
So in the IA, the transfer order has been stayed or what?
That the stay order was modified, my lord.
Your lordship is hearing the matter or my lord is just briefing the fact, my lord?
So the fact, so now, see, what is the stage for today's WPC? Let's just see. Because I've heard,
It is a
My
fixed
lord,
matter.
what is the
So far,
stage
my
today?
main petition concern, my lord, today is listed, actually today is listed for IA, not for the main, my lord. Because my brother, he wants to file an affidavit. If your lordship see the last order 26/9, my lord.
However,
He
isn't
showed the
the
time for
subject
filing
of further
affidavit.
orders in this interim order in the next date of listing?
Yes, my lord.
Now,
that's-
the order is passed for the IA.
IA, my lord, not in
Uh-huh.
main petition, my lord. And my brother is arguing for the main petition, my lord.
Wait, so the operation of the order dated 23/09/2024 passed in WPC 429. Shall remain suspended.
And time was given, my lord. I think 4 weeks or 3 weeks time was given to file the affidavit in IA, my lord.
No, today
No, no.
was the
No,
fixed.
however, the interim order is subjected to.
You have
further
not filed the
orders
No, that's
reply.
why I
You
have, my lord,
that
I
will be passed in the interim application on the next. So,
So meaning thereby in IA money, you don't have any grievances. We can take a,
now, so what do we do now? Today?
so for my lord, for proper hearing, my lord, pleading has to be completed. Not even a requisite copy has been served to us, my lord. So we thought, my lord,
So
he
no,
filed
this
the,
order, this is the IA.
Yes,
okay?
my lord.
In the IA, it has been listed for today.
correct, my lord. And he was supposed to file the affidavit in IA, my lord. He has not
Written
filed the
objection-
affidavit.
Written objection in
No,
the
no,
IA.
that's why I wish not to file it.
So
That's all right.
So
because-
the IA is to be disposed of, you're saying that let this IA be disposed of along with the writ petition.
My lord, no, my
Is
lord.
it? side
Your
by
lordship may
side?
dispose of saying that he don't have any grievance with IA, my lord. So for main petition concern, let him serve the requisite copy, my lord, so that we can take an instruction
Yes.
affidavit from the
So the
department.
IA now,
My lord,
since
I am-
in the IA, you're
my
not
lord,
You
filing.
cannot say both sides, my lord.
Since you're not
My
filing any
brother cannot
written
claim both sides,
objection,
my
yes.
No.
In the IA, we will leave the IA
No, no.
aside.
Yes,
No.
your lordship may close down the IA with the
No.
observation as he has submitted by my lord that he is not going to file
My
the
lord,
Finish.
my lord, I don't know whether the learned additional AG is the counsel for the petitioner or
Anyway,
for the
No, no, no.
respondent.
So
No,
now.
don't submit
now
that. No,
in
no,
the
no.
main-
You allow me
Okay,
to
madam.
make,
No. You
you
can't say it like
you
that.
cannot,
So we are
No,
not
you
dealing
cannot.
with the IA
You cannot.
today, we
You
are
cannot
dealing with the
startle
main
me
writ
this way.
petition. Okay.
I was just referring to the
Okay.
other past
Now,
the court
in
only.
the
No,
main
no.
writ petition,
Madam-
are the respondents duly represented today?
Yes, my lord.
Huh.
I am for the,
That's why, my lord.
I am
That's
for the
why
government,
it
I am for
All
the
the
brother respondent.
respondents are represented.
Yes,
why,
my
my lord,
lord.
Now,
I-
do you want to file a counter affidavit?
Provided requisite copies are sent,
Okay,
served to
so
us, my lord.
copies have not been
Not even
received.
served, my lord.
Okay.
So
So
pleadings
you-
are not
you-
completed,
you
my.
want Copies of the writ petition,
Yes.
then
My
let
lord.
them
Has to be
give them a
completed, then
chance
only you can go
to
for
file
appeal.
their counter affidavit.
My lord,
Service is not completed in writ petition, my lord.
Okay,
My lord,
service too,
my-
but
my
there's
lord,
no such
let-
order.
my lord, let me pace it.
Uh-huh.
The first thing I got aghast with my brother before I started my argument, trying to distract my argument. That is not supposed to be done.
No.
One.
I was
And-
just asking whether he's
No,
for
I did not
final
say-
hearing or not, madam. Because final hearing cannot be done.
And number two, my lord.
You can't submit like that.
Number two, my
And
lord.
what happened last time, madam?
Let
No.
him complete his submission.
I'm sorry, madam. I'm sorry to hear that.
You were not there that time when the incident took place.
No, no.
You came with
Come
me.
on, don't say like that. I was very much present on that.
So now,
Remember you-
IA, we are not dealing with the IA,
No,
we
but-
deal with the
no,
main writ petition.
That-
So you've made your
that's why-
submission,
That's why, my
Uh-huh.
lord, I have simply said in the beginning, no counter filing of affidavit is required in any of the applications because it is pure question of law.
Okay, even if it's pure question of law,
Correct.
if the respondents
Hmm.
feel that they're required to file their counter affidavit, why not give them a chance?
We
Let
give
them-
them.
let them- okay, give
It's
them a
okay,
chance,
it's
let
okay,
them
Milo.
file.
That is
That-
not an
that-
issue.
That's their prerogative. If they want to file a written counter affidavit, let them do it.
Right.
Okay.
1 week time. I'll furnish extra copy to them because Milo, there is nothing to file as a counter affidavit. Only on the question of law. If they can overcome the question of law, then I have no case. I will simply say, Milo, I will withdraw this petition.
Your submission is that this is a covered case by
No,
the
madam.
judgment which he has
Yes,
said.
ma'am.
Okay.
That is the submission of
So,
petitioner
this is
and
the
we'll try our
submission.
best to distinguish
But
that
you
also.
file your counter affidavit and also address to the point made by him that this is already a covered case.
Yes,
So
ma'am.
you're going to reply and let this court know whether this is actually a covered case or not.
Mala will
Only
distinguish.
one issue, Milo, that's simple.
Mala, let them Mala sub a requisite copies, Mala, so that you can
Yes,
seek
yes, yes,
instruction
you
from the
can copy,
department.
Yes.
So
Take
Mr.
use of
Mr.
your assistants. Your staffs are there, get the Xerox
Learned
copy.
counsel for the
No, no, no.
petitioner.
Don't submit like all these things.
Hi,
that's
Mr.
not
Taro,
related
learned
to
counsel
serve you
for
the copy.
petitioner along
No,
with
Mr.
You
No.
can't submit like this. This is your duty to
uh,
serve a
number.
requisite copy.
learned,
Very unfortunate.
learned additional AG for respondents number
One, my lord, I am only for
One.
one, my lord.
and Mr.
And correspondent number 3.
for respondent number.
Let us be
three.
fair to this court, my
The
lord. Let
learned
us- let
counsel
us-
for the respondents submit that they have not been furnished the copies of the instant writ petition. In view of the above, the learned counsel.
Even
for
my
the
lord, in the
petitioner
main petition,
is to-
notice was not issued to the private
is,
respondent.
is to furnish copies of the writ petition to the learned counsels for the respondents number 1 and 2 and listening. Okay. Notice be duly furnished, duly issued to the private respondents number.
Notice was issued.
Number 2 is not before the report.
No, private respondent number.
I'm for private respondent.
Okay, so 3. What about 2?
Services, I think not completed, so.
Okay, it is seen that, wait, let's see in the court whether notice was been issued.
Milo, that is
in
minister,
the
Milo,
order-
that there is one
So
judgment.
issue notice, it's there, notice it is saying that return of service of notice upon respondent number 2 is still awaited. The learned counsels for the respondents are to file their counter affidavit.
Short period, 1 week. There's only question of law, whether they are there or not.
Within a period of 2 weeks.
Fixed date,
And
Milo,
the
fixed date.
learned counsel for the respondents are also to address to the submission made by the learned counsel of
Mother,
of
what
the
are pleadings in the
petitioner that-
repetition, my lord? Yes, my lord. What are pleadings in the repetition, we will try our best to
Okay.
respond to that.
And then besides that, there's submission, okay, that this is a covered matter
11, Milo.
in,
Hibutama versus State of AP.
yes,
We are aware of the judgment, my lord.
2024.
reported in 2020 for GLT 497. Accordingly, list
After 2 weeks, my lord.
after
On
2 weeks.
11th,
On-
11th, 11th.
On 11th? 11,
11,
11.
11.
Why fix that? We are a local council, madam. Provided when my brother.
Okay.
Sabha has a requisite
Anyways,
copy.
so
Definitely.
will you be ready by 2 weeks? You have a copy first.
Mala, let him Sabha has a requisite copy, mala. Yes,
So
mala.
we'll list
Provided-
after 2 weeks.
Yes.
If you want, you can.
Everything I will do tomorrow, Milo. On
Or-
11th November.
11/11/2024. Yes.
And my lord,
Great.
order pass in the IA, we continued, my lord.
Okay.
Order pass in IA.
Because that was still today, my lord.
Till today. So
The,
it's-
the order,
No, but that has been suspended, Milord. No further continuation is required.
let's see,
No, no,
let's
no.
see the order, let's see
No,
the
no,
order,
no.
whether anything is
Kindly
required.
check the order, my lord. It's still today, my lord.
Okay, the interim order passed in the IA 180/2024 dated 26/09/2024 is to continue till the next date of this.
Then what about the private respondent too, my lord?
We are waiting for the return of service of notice. Notice was already issued.
I'll
in
take
the
Dusty.
press.
I'll take Dusty because he's a home minister.
Oh, is it?
Yes,
He's
well,
very
there is a division judgment of our division bench. But normally the politician who initiates the UO note, it is not mandatory to make them party also. But here, since I have not laid my hands very fairly, my lord, I am on an engaged case, my lord. I have not touched the brief, everything. Yet
I'm sorry,
I
my
know
lord.
what has done
When you're
is-
making them out of ID, my lord, that's why you have made them party.
So respondent number 2, we're still awaiting for return of service.
Correct.
Yes. Hmm. Yes. Yes.
My lord,
Sorry,
this is
Mo.
relating to perjury committed by respondent number 1, 2, 3, and 6. My lord, I have a private plot of land at Tamachungchung. It was occupied by Assam Rifle in 1968. And the land was handed over to ITBP in 2004. The total area of land was 187 acres. But they have denied that it was not 187 acres, which is false. Thereby, they have committed offense of perjury in the proceeding of the case before this court.
How can you say that?
Yes, my lord. Let us see then one by one.
This is what? This is an
This is,
application filed under 379.
yes, my lord.
Read with section 215 of the BNSS.
Yes, my lord. To
To
initiate
prosecution
prosecution against,
a respondent number. What sort of an application is this? Anyways,
my lord. My lord, they have filed affidavit in the writ petition, number 343 of 2023. In para 5 of their affidavit, what they have said, kindly, your lordship may please to turn to page number 35.
35 of the,
I have annexed the copy of the affidavit in the IA,
okay.
IA itself.
This is affidavit in opposition filed by respondent number 1 to 3. Is it?
Yes, yes, madam. Para 5. Page number 35, para 5. It states, madam, that with regards to statement made in para 3 of the writ petition, the deponent states that under reply or matter of facts, and Assam Rifle was under the occupation of land at TCC, and after that ITBP took the possession and the land at TCC, but the same is never demarcated by the concerned authority. One, never demarcated. Now next, and hence it is incorrect to say that the whole 187 acres of land is under the direct possession of the Assam Rifles and ITBP thereafter from 2004. There are two issues. One, it was never demarcated, and another, 187 acre was not in the possession of ITBP. Now let us see, my lord, page number 43, annexure 3. This is not so clear. Next page is true copy. Subject says, my lord, survey of land for ITBP can passes in Upper Subansiri district of Arunachal Pradesh.
Yes, so
It says, sir, kindly refer to this office letter number so and so. So many letters have been referred. Second last line of that paragraph, by which your good office has been requested to intimate the date for conducting survey of land at following BOPs of this unit. Now, my lord, come to para 3. It is therefore once again requested to your good self to look into the case personally, initiate the survey process at the following 4 locations in favor of 10 BN ITBP. Here there is a one table. In the table, serial number 1, TCC, 187 acres area has been mentioned.
So they have admitted in their letter that there is 187 acre in their possession. But in the affidavit in paragraph 5, they have said they are not in occupation of 187 acre. Now come to the next point. Page number 45, next page, madam. Annexure 4. Para 3, my lord. So it's para 2. This is letter written to Deputy Commissioner by Commandant of 10 BN ITBP Police. In para 2, my lord, in the subject letter, measure of TCC post has been mentioned at 1.87 acre, which is grossly wrong and far less than the land size handed over to ITBP by AR on paper 187. Here also they have made clarification. There was a mistake in the letter to the Deputy Commissioner that 1.87 acres are there. But that has been clarified by this letter. It was not 1.87, but 187 acre.
So in you can reply to the counter affidavit, isn't it? Pointing out all this.
No, they have filed affidavit. And in
So
their-
you can reply to the so you're pointing out the defects in the counter affidavit, isn't it? You are pointing out the discrepancies which are found in the counter affidavit filed by the respondents. So you can file your reply. You can file your reply to the counter affidavit filed by the respondents, isn't it?
My lord, that can
Pointing
be,
out all
yes,
this.
yes, but that can be done in the, that can be done in the
But
writ
this is an
petition.
application for initiating a case.
That can
of
be done in a
perjury.
writ petition, my lord.
Uh,
That can be done in a writ petition. But they have committed offense of perjury.
How can you say that?
Yes, my lord. Then regarding demarcation also, they have said that it was never demarcated. But in the next page, page 46, my lord. Page 46. Last.
Anyways, we'll issue notice.
All right, all right.
Okay. Do we require to issue notice? What are you going to say about this?
It is not maintainable at all, my lord.
I know, that's what.
Yes.
See,
We'll file objection.
you file your objection. Since it's IA, we will have a hearing on this. Can be disposed of. See, because you're referring to the counter affidavit filed by the respondents, and you're pointing out certain discrepancies in the documents. So that what you're pointing out today, if you want, you can address to that by filing a reply to the counter affidavit filed by the respondents. Oh, why have you filed an
My lord,
application? Anyways, we'll issue notice, let them
Please,
file
issue
their written objection.
Issue notice, we'll have a hearing.
Instead of disposing it off straight away. Anyway, heard Mr.
Yes, Koyang.
S. Pal, learned counsel for the applicant, who has filed the instant application under section 379, read with section 215 okay, of the Bharatiya Nagarik Suraksha Sanhita, 2023 within brackets BNSS, to initiate prosecution proceedings against respondent number 1, 2, 3, and 6 for perjury, which is punishable under section 229 of the Bharatiya Naya Sanhita, 2023, BNS. The learned counsel for the applicant submits that on perusal of the counter affidavit filed by the learned counsels for the respondents, certain discrepancies have been found, which appears to be an attempt to commit the offense of perjury and mislead the instant court.
My lord, in place of discrepancy, false statement, I have made
Okay,
allegation.
instead of certain false statements have been found to be made by the respondents. issue notice to the respondents, and then Mr. So-and-so, learned edition AG, accepts notice on behalf of opposite party number. You are on behalf of opposite party number
1, 2, and 3, madam.
1, 2, and 3, while Miss So-and-so accepts notice on behalf of respondents number.
I have already filed my affidavit.
That is in the writ petition.
Deputy Commissioner. In the writ petition, I have already filed.
So
my-
in the IA,
No,
you're going to accept notice on behalf of
Madam, respondent number
the state
1,
respondents.
1, 2, 3, and
Against
6.
1, 2, 3 only.
Okay.
Against Union.
6 also, madam.
Okay, so 1, 2, 3, and 6.
And 6.
While you are first standing counsel for?
Respondent number 4.
For respondent number 4. In view of the above, not need to issue any formal notice. Any private respondents? No.
No.
Respondent number
The
6. No.
learned counsel for the opposite party / respondents are paid for time to file their written objection. In view of the above, less after 2 weeks.
Yes.
Okay.
Obliged.
Meanwhile, copy of the requisite, copies of the IE. Okay, receive copies to be duly furnished to the learned counsels for the respondents. Yes. Yes,
Madam, this is regarding transfer and posting. Madam.
again, so many cases concerning
Yes,
transfer. and
yes,
posting.
madam. Yeah, my lord.
Item 14 and 15 are analogous matter.
Huh.
Can be taken up.
So what is the stage?
My lord, pleadings are complete. If your lordship deems it convenient, my lord, it can be taken up for disposal or.
Pleadings are complete?
In respect of private respondents, I think
Pardon?
private respondents,
Private respondent is being represented over.
Okay, so private respondents, we have to wait. Are they represented?
They're represented, my lord. But the counsel is not here. Otherwise,
Okay.
my lord, let it be fixed on Tuesday for admission hearing, my lord, for disposal. Because they are enjoying the stay order.
So now the private respondents, have they filed their?
No, my lord,
counter?
on the last occasion, it was submitted, they are not going to
They're not
file,
going to
go
file?
along with the
Okay.
affidavit of the.
Mr. Is it?
madam.
The learned counsel for the petitioner is present along with Mr. D. Pangin, learned counsel for the state respondents.
Bank, my lord,
Bank.
respondent bank.
For the bank respondents.
That's 1 and 2, my lord.
None appeared for the private respondents. It is submitted by the learned counsels that pleadings are complete and that this matter can be listed for admission hearing. In view of the above, list on, to make it a week after. List on. Make it 1st November. Okay, in view of the above, list on 1/11/2020 for admission hearing.
My lord, interim order is there. Interim order
Meanwhile, the interim order passed earlier shall continue till the next date of listing.
of like.
Item 15, lordship, it's analogous. for the
Same.
same.
Okay, same order for item number
15.
15.
Item number 16.
May I please, Your Lordship?
Hmm.
Your Lordship, I was directed to take dusty service upon respondent number 6
Hmm.
on 39/2024,
Hmm.
Your Lordship.
So.
I have taken
you
the dusty.
taken-
Yes, Your
take
Lordship.
from- so have you filed the affidavit?
No, they have appeared, Your Lordship.
Oh, so you have
yes,
appeared,
yes,
respondent number 6
yes.
represented.
This morning I have filed Wakalat
Okay,
Nawab.
so, are you going to file a counter?
Yes, Your. So I need some
Okay,
time, Your. At
uh,
least 2 week time may be given because we have received on this 15th
Yeah.
of this month, Your. May I please, Your Lordship? There is an urgency, Your Lordship.
Mr.
Enjoy, Your Lordship.
Evenjo, learned counsel for the petitioner is present along with Mr. G. Tarak, is it? Standing counsel for RWD. And Mr.
T. Bagang,
T. Bagan, learned counsel for respondent number
5 and 6.
Five
or
and six,
respondent
yes.
number 5 and 6. The learned counsel for respondent number 5 and 6 has prayed for time to file their counter affidavit. In view of the above, let's.
Your Lordship, matter may be kindly fixed on 30, Your Lordship, of this month. If
At least
possible,
2
Your
weeks
Lordship.
time, because there is
It's a matter
numbers
after
of
2 weeks.
documents involved.
2 weeks. On a date to be fixed by the registry, it is submitted that the learned standing counsel. It is submitted by the learned standing counsel for RWT that they have already.
In that
filed
case,
their
Your
counter
Lordship,
affidavit.
may I pray for fixed date?
2 weeks,
Yes,
when will you be
fixed date.
ready on? Give me a date after 2 weeks.
Yes.
Can it be on
Any
6,
date?
6 November?
That's 2 weeks, 6/11/2024. Yes.
Much obliged.
Duly obliged.
Yes.
My lord, service outcome respondent number 2 is awaited. In respect of respondent number 1, my lord, is this all?
Through Dusty. So
Yeah.
have you
I
filed
filed
the
my-
affidavit?
Yes, ma'am.
But none appeared for respondent number 1?
1, yes, ma'am.
Hmm.
There's no paper.
Okay, Mr.
H. Lam.
H. Lamu, learned counsel for the petitioner, is present and submits that notice is duly served to respondent number 1 through Dusty service and affidavit to the effect has been filed. Let's see the affidavit. On perusal of the affidavit of Dusty service, who is respondent number 1?
State Bank of India.
It is seen that the notice was received. Name is not given.
Name is not given, their seal is there. State Bank of India.
Was received wherein a seal of the State Bank of India dated 19/9/2024 has been affixed to the notice. However, it is saying that none appeared for respondent number 1. In view of the above, list the matter after 2 weeks awaiting for the respondent number 1 to be duly represented. After 2 weeks.
All right.
Do they have a standing counsel, State Bank?
They
Any
are
idea?
standing counsel. madam.
Maybe we have to wait for some steps to be taken.
Yes, my lord, on earlier occasion, my lord, on last order, my lord, my interim was supposed to be considered today, my lord.
But
Yes,
let
madam.
them be
My lord,
present.
let it be on next date, madam. It may be considered interim order.
The interim order prayed for by the learned counsel for the petitioner is to be considered in the next date.
Obliged, madam.
See, stamped by, dated so and so with State Bank of India, okay? Therefore, notice is deemed to be complete upon respondent number 1, however, none appeared for.
Obliged.
Yes,
Your Lordship,
this is hearing.
this is hearing, so I am afraid I have argued this matter at least 2 or 3 times before and it was part heard and time would run out. So I have a suggestion, Your Lordship. Both sides may be allowed to make a short compilation and a very short date may be kept for the hearing. Because otherwise I'll start the arguments, it won't be over, Your Lordship. So if you are allowed to make short compilations, if they want to, I would like to make a short compilation that would cut down the time that would be required for the hearing. And it could be kept on the next week.
Fixed for hearing, is
Then
it?
fix it for hearing, Your Ladyship, on maybe 29th or 30th.
See, 29th or 30th, it will not be very feasible because this bench will
Whatever,
not
whatever
sit
is
after
feasible,
next week.
whatever
So,
is convenient to Your Ladyship.
okay, now.
Because
it
this will
appears
require
that
time.
This matter was part heard. And then
No,
it
yeah,
was
it was
released.
released.
It was
2 or
released
3
from
times.
the-
Yes, 2 or 3 times it has been released.
So we'll have to fix the matter maybe on a Monday or a Tuesday.
As
So
Your
that
Ladyship.
whichever bench comes and sit, they will sit for a little bit longer period.
Fair
of
enough,
time.
Your Ladyship.
Isn't it?
And we may be allowed to
submit short
Yes,
compilations
submit-
across the bar.
Submit to the, he's requested that he may be allowed to submit a short compilation of his arguments in a written form. So you can do the same and then we'll fix it for hearing on the next date.
Leadership may fix it
But
for
that
hearing
matter-
now and give us some time for submitting compilation. Short.
Or that you're saying
You-
that I hear the matter.
No, your lordship,
Today.
what I'm saying,
When-
requesting,
Time-
your lordship, what I'm requesting is the shortest time may be given for submitting a compilation, which may actually,
After the matter is heard.
that is a written submission, lordship. You will obviously give us the option to do that. I am suggesting that the matter is very voluminous. There is a lot of repetition. So if we give a short compilation to you, even across the bar, at the time of hearing, that will aid in the hearing of the matter to be completed in a much shorter time. Maybe half an hour or 1 hour only. Otherwise, my experience is this matter, one side takes more than 3 hours.
That's what, no? If the matter is placed, supposing before this court, okay? And as per your experience, the matter is very voluminous. So you're saying that you have been making your presentation a few times. So when you made your previous presentation before the whichever court that was sitting, that court had the advantage of hearing it thoroughly and asking questions.
Both the times.
Now finally, you're saying that this court may not hear the matter
No,
so
no,
thoroughly.
your ladyship, that's
and
not.
a short compilation.
No,
be made. Now, would it
not
be
your,
correct?
not at all your ladyship.
Ha.
I'll tell you exactly what I'm saying. Suppose I am referring to one document. Now that document, to open that is in the 6th volume or the 4th volume. There are nearly 10 plus volumes here.
See.
So these are 3 writ petitions with joinders, rejoinders and writs.
I get your point.
Yes, sir.
But only thing is,
It will be comprehensive.
from what you're submitting, it appears that this case, being slightly maybe complicated, needs a voluminous hearing. So if it needs a voluminous hearing, it has to be heard thoroughly, which will take maybe, because we have been having cases where the hearing continues maybe for 2-3 days and then finally, then it should be before the same judge, the same sitting judge. Okay. Now, today, if supposing we start the matter and we hear the matter, maybe it will be completed today. I don't know, because you are more aware of what.
Ladyship,
And
will
it
take a
appears
little time, yeah.
from on perusal of the orders that were previously passed, that the respondents have not had the chance to make the submission.
Exactly. Exactly. your
May I
ladyship.
propose, since still we have more than 2 hours for 2 days. also. My friend can start today and we can continue to tomorrow or day after tomorrow. In one day, also, it can't be concluded. Anyway, 2 days will be required.
Your ladyship, unfortunately, I am scheduled to visit Kohima tomorrow. I'm leading a delegation for the virus.
Then
that is happening.
the matter
It can be
is
kept on
Monday.
29th, 30th. Next week it could be kept, I'll come. 2 days consecutively.
This bench is
Next-
not going to
next-
be it's not going to sit for a long time next week. Okay, most probably.
Monday, Tuesday.
the
I
last-
think next week,
Ah,
lordship is there.
next, no, I will not be there for the whole week.
No, Monday, Tuesday, your ladyship. Monday, Tuesday, if your ladyship is there,
Can we list it for before some other bench?
whatever your
Okay,
ladyship
whichever,
thinks suitable.
whichever. You see, because most probably the whole of next week, I'm not going to be here. I'll
Oh,
be taking leave. Okay. So.
I would
because
have
of
loved
that,
to stay back, your ladyship. Only tomorrow I have this problem. I have to be.
Otherwise, if we hear it today and continue maybe
Yeah.
this week, it's a different matter. But if the counsel for the petitioner is going to be available only today,
I'm available today, your ladyship.
then it will be
Then.
again
Then next week, Monday, I'm available again, your ladyship. Monday, Tuesday, I'm available.
Monday, Tuesday, but before afternoon, I'll be there for Wednesday, I'll be leaving.
So forenoon, your ladyship,
So
forenoon should be
then
enough.
for the respondents, it will be a bit difficult and we'll be rushing the matter. There'll be other cases also. Isn't
Your
it?
ladyship, as you think fit.
And therefore, we will make it short
Yeah.
on the submission made by the learned counsels for both the parties. Due to paucity of time, list this matter on, give me a date. On,
Your ladyship, it's
Your ladyship has to find a date where it can be started just immediately after lunch and continue for 2 days if needed.
No, any
So
other.
if I give her, your
Make it on
ladyship,
a
what?
Monday so that it can
Yeah,
continue
fair enough. So any
Okay.
Monday, your ladyship.
on, so when will you be available? Maybe on 2nd December?
Yes, that's fine. 2nd December is fine for me.
Respondents on 2nd December 22.
But your
Because it
ladyship,
appears that there's no urgency in the matter.
no, there is urgency, your ladyship. The problem is it cannot be done in a short time.
7th is Saturday.
There is a lot of urgency in a matter, your ladyship.
Oh, yes. I mean, make it on the, maybe 4th November then?
4th November is fine. 4th November is fine.
I'm picking a Monday so that at the start of the week you can continue and continue for the rest of the week, isn't it? Whatever. So make it
Yeah.
4th November.
Okay. Let it be a fixed matter, your ladyship, high up on the board.
That's a fixed matter. Yes.
No, your ladyship, yeah. This is a short matter, your ladyship, so I can impinge on your. Ladyship, these are two matters which are analogous. I'll be depending on the writ of 32. Right.
This is challenging a notification, is it?
Yeah, this is regarding a notification which has some inherent flaws in it and contradictions. I'll take you straight to the notification on page 29. This is regarding a high tension transmission line and compensation for that. Your Lordship, the notification is, may I read page 29?
Yes, impugned notification.
Impugned notification is page 29. I read the relevant para. Para 2. Para 2A says, for tribal population is identified in para 3 of this policy who are not entitled for any benefits, including compensation of specific nature, resettlement or rehabilitation benefits, an ex gratia package amount equivalent to half the rates notified would be payable. Now, your Lordship, let's read para 3, which is on the next page, 29A. 29A says, para 3, for identification of the affected individuals where right of way has been duly granted by the competent authority in reserved forest area, a board of officers shall be constituted by deputy commissioner concerned at district level, akin to board constituted in matters related to land acquisition. The representative of forest repository shall necessarily include in such boards for identification. Your ladyship, para 3 is as per law. The law is that even in reserved forest areas, since 2006, we have this new act under which the rights of tribals and traditional forest dwellers, the 2006 Forest Act.
Okay, yes, yes.
Now, as per, I'll just give you a copy of the same, but I have a copy of this. So as per that act, your ladyship, the rights of forest dwellers are crystallized. And
Where's we are mentioning, we are referring to which act?
2006 Forest Dwellers Act, the right to rehabilitation tribal.
Oh, 2006.
This he's showing, I
Forest
think,
Dwellers
the older
Act.
act.
It's not here.
27. I'm talking of the 2000. I'll just try to give you a copy. I had brought a copy with me. I have actually.
Forest Dwellers Act.
That's right. That's it. It's also commonly known as Forest Act of 2006. I'm not having much help today, which. So the main point I'm making, your ladyship, is that this notification in para 2 is ignoring the rights as crystallized under the Forest Act, but in the, I'll just find and give it to your ladyship. Let me continue with the presentation. So what happens is this para 3, which is as per the Forest Act, is asked for the forest person to be there. It asks for identification of people affected, but it is in direct contradiction to para 2, which is talking about people who have no rights. Now, why has this confusion come, your ladyship? That comes from the fact that they have only considered the Electricity Act, which is a 2003 act which precedes the Right of Forest Dwellers Act. What I am humbly submitting, your ladyship, is that as per the notification of page 30A, your ladyship goes to page 30A, there is a notification. This notification lays down the rates that are applicable to power transmission lines for land as well as for right of way. This is a 29th August 2019 notification. This is in pursuance of, your ladyship, may I read first para?
Yes.
Yeah.
No.
The Governor of Arunachal Pradesh is pleased to adopt and notify the following rates of payment: compensation towards damages in right of way for the transmission lines in accordance with guidelines of Ministry of Power. Reference so much for maintaining uniformity in compensation payment to the affected landowners during construction of transmission lines. And this goes on to say, these guidelines of payment methodology to compensate damages stipulated in section 67, 68 of the Act. Ladyship, I'll very briefly take you to 67. What 67 says is that fully damages have to be paid to the affected person. The term used is full damages. I'll put that. And section 10 and 16 of Indian Telegraph Act also talks of full damages to be paid. What they have done, your ladyship, in the notification which I just perused,
Half. It says half.
that is arbitrary, your ladyship. And it is not
But
only.
see, when it says half, the first part of the notification says those who are not entitled
Exactly,
to
your
any
ladyship.
benefits.
Now, there is a very interesting point here, law point. The law point is as follows. First of all, the compensation is coming from the Ministry of Power, from the transmission line, people responsible for setting up the transmission line.
Yes.
Your ladyship, they are mandated by law to pay compensation to affected parties only. They cannot give to unaffected people.
So you're saying that these persons mentioned in para 2 are not affected, or they are affected?
Your ladyship, we are affected people. We have completely been ignored because of para 2. What has happened is, I take you again to another document, your ladyship, which is again an important document. Kindly see FRA certificate on page 71. That is the forest certificate. This is this. Now the FRA certificate says, it talks about the land required total 119 hectares. Then there is right of way in the first para. Now second para, I read, your ladyship. Clause A, the complete process for identification settlement under the FRA's Forest Rights Act, your ladyship, copy of which I shall provide you, has been carried out for the entire 119 acres land diversion. Not true, your ladyship. In reserved forest where we are there, no survey has been done. Why it hasn't been done? The mystery is unfolded in para C. The diversion of forest land for facilities managed by government as required under Sector 3(2) of FRA Act has been completed, and Gram Sabha, not true in our area. C, let's the cat out of the bag. The proposal does not involve recognized right of primitive tribes group and our agriculture community not applicable in this area. Now, this has come arbitrarily here.
So this part not applicable in this area.
That's not true, your ladyship. By the 2006 Act, anybody who has rights, who's a tradition, who has been for 3 generations, who has been there from before 2005.
So they are dwelling within that area. Is it?
Yeah. Your ladyship, all we are asking, what are we asking? That there has been, seems to me, there has been an error here because of some logical miscommunication between the parties. Because in one document they are saying, in the cabinet notification also, your ladyship, they are saying that the Forest Rights Act should be taken care of. But when it comes to
Giving the compensation, is it? They have
not
been
only giving a
excluded?
even identification,
Okay.
they are saying
So,
arbitrary.
but they are not completely excluded. It's only that half the amount.
It
Is
is
it?
not only half the amount. They have to be given to people who have no rights. We have rights under the 2006. All we want your leadership is that identification must be done properly. And this your court, this court has ordered similar. You can
Okay, so
continue after.
continue after lunch because it's one now.
Much obliged.
Yes. I
Yes.
think we can
Your
continue.
leadership, may I take you to page 65? Page 65 of 32, writ petition number 32. Leadership, I already shown to you the impugned order, the impugned notification. And I have shown that the impugned notification is without reference to any statute and declares compensation for people who have no other right. Now, the impugned notification is based on a cabinet note, which I am showing you now. Page 65. I read para 3A, 3B actually. Proposal for right of way in reserved forest lands. And for tribal population occupying reserved forest lands coming under specifically granted right of way under the right of way comprehensive scheme who are not entitled for any benefits including compensation of specific nature, resettlement or rehabilitation, ex gratia relief package. Now, your leadership, kindly contrast this with the 2019 notification on page 30A. Page 30A. There's an important legal point, law point I want to make. Page 30A. August 29, 2019. Page 30A. 30A.
Yes.
Your ladyship, if you notice the very first para clearly says that this notification is under Section 67 of and 68 of Electricity Act, Section 10 and 16 of Indian Telegraph Act of 1885. This is a notification under a statute. This flows directly from the Constitution, where under Article 300A, nobody can be deprived of his property without due process of law. Under the Telegraph Act and under the Electricity Act, there are provisions, namely 67 under Electricity Act and 10 under Telegraph Act, which clearly lay out that affected persons must be compensated in full. I'll take you to that. Now, here, under those provisions, a rate has been laid out. Now, this document has the force of law. Whereas the document which emanates from the cabinet note, which is the impugned notification, would have had force of law had there not been any statutory provision on that ground. As there is already a statutory provision, a contradictory or even supplementary provision cannot be created like this. It has to be with reference to the statute.
Okay.
This has the force of an administrative order. The impugned order, the notification, has the force of an administrative order, which, as per residual power, suppose there is some calamity somewhere, government can, with its financial powers, they have the financial purse strings in their hands, they can give ad hoc payment to somebody who doesn't have any other.
The
Here-
31st August, that one.
That one.
Uh-huh.
That one, 29th August is the one which has statutory, which has the power of law. I mean, it holds the field as per the law applicable to the field. Whereas the earlier the impugned notification of 31st August,
31st is the one.
that one is just an administrative order. And as I pointed out earlier, para 3 contradicts. Now, the clarity regarding para 3 will come from the cabinet note. On page 66, cabinet note section 4, para 4, I read, page 66.
Yes.
For identification of beneficiaries and assets thereof, a board of officers is constituted by the concerned DC in matters related to land acquisition. In respect of ROW guidelines issued by the Department of Power for identification of beneficiaries in non-forest areas with specific requirement of identification of beneficiaries in RF is reserved forest areas. RF is very clearly saying that in this also it is needed. Areas having notified tribal rights. This is the act I was referring to. I'll take your lordship through that. As per FRA or notification constituting reserved forests may be followed. Lordship, clearly the cabinet note is noting that there are people there who have rights. I think, now I am surmising your lordship, I'm trying to be of aid to your lordship. If you turn the page and come to page 68, perhaps mischief has come from here and government has been actually trying to be helpful, but could not interpret the law, the coordinates they were working on clearly. If you see page 68, this is a note from Secretary Land Management, which says that we have taken consultation from Law Department, and what it says is, I read para 4. There is no requirement to show notification inviting claims and options setting up transmission lines in reserved forest areas. Our ladyship, the mistake they have encountered here is the Electricity Act is a 2003 Act. It could not surmise the following Act, which is 2006 Forest Act, which crystallizes the rights. I'll go through that. But I'm just trying to point out where the problem is arisen from. So, after this cabinet note, what I would like to show your ladyship is basically how the rights are crystallized. If your ladyship now has the Forest Rights Act.
Yes.
Just the very first para, your ladyship, and even the title of the act. I shall read. The Scheduled Tribes and Other Traditional Forest Dwellers, brackets, Recognition of Forest Rights Act. This act is all about recognizing the acts of forest dwellers and giving them quantifiable rights, civil rights equivalent kind of rights on land. First para, an act to recognize and vest the forest rights and occupation in forest land in forest dwelling scheduled tribes and other traditional forest dwellers who have been residing in such forests for generations, but whose rights could not be recorded. This is point 1. Then, your ladyship, we should go to para 2,
Section.
In this act, this is definitions. I just want you to see 2 definitions. 2C. Leadership has 2C?
Yes.
Yeah, I read. Forest dwelling scheduled tribes means the members or community of the scheduled tribes who primarily reside in and who depend on the forest or forest lands. And 2D is also relevant. What is forest land? 2D says means land of any description falling within any forest area and includes unqualified land, unclassified forests, undemarcated forests, existing or deemed forests, protected forests, reserved forests. I am concerned with my case of reserved forests. Sanctuaries and national parks. Then, your ladyship, going to clause para 3 in this. Forest rights. It also shows what are forest rights. I read A. Right to hold and live in forest land under the individual or common occupation for habitation or self-cultivation. C. Right of ownership. I clearly have a right of ownership under this act. And G, which is relevant, right for conversion of pattas or leases or grants. So these are akin to classic property rights, which our citizens who are dwelling in forests were deprived of. This act has given them the umbrella cover of these rights. Now, I also would like to take you very shortly to to the Electricity Act 2003. Electricity Act 2003. Electricity Act 2003. 67. Should be around page 38 or so.
Okay, section 67. Oh.
67. 67(3). It will be on the next page. 67(3) I read. Leadership has a licensee shall, in exercise of any of the powers conferred by or under this section and the rules made there, cause as little damage, detriment and inconvenience as may be, and shall make, the next phrase is very important, full compensation for any damage, detriment or inconvenience caused by him or by anyone employed by him. Question of partial payment or half payment doesn't arise. Whatever under the law is a notified amount, full compensation has to be paid under the Electricity Act 2003. Your Ladyship, now coming to the Telegraph Act. Your Ladyship has Telegraph Act. Coming to
How do you assess the compensation on?
Your Ladyship, that is an exercise, as I just read to you.
By a
through your-
certain,
it is akin to land acquisition. It's not land acquisition. It is akin to, the assessment process is akin to land acquisition.
Okay.
And wherever there is a tower, they have a set meters, which they say is to be compensated for. And wherever the line is going overhead, then some width, 20 meters, 30 meters,
So
whatever.
there's a certain yardstick.
And they have a rate fixed, as I showed you in the 2019 notification.
Okay.
So the rate is fixed, the width is fixed.
So as per the rates, there should.
And also,
be
your
going.
Ladyship, one more thing is there. It is defined how much KVA. The compensation also depends on the KVA tower, how much electricity is flowing. Ladyship, para 10. Power
Section 10.
10 in the Indian Telegraph Act. If you see clause D, 10D, I read, in the exercise of powers conferred by this section, the Telegraph Authority shall do as little damage as possible, and when it has exercised those powers in respect of any property other than that referred to, clause E shall pay full compensation to all persons interested for any damage sustained by them. Now, under this provision, I take you again to 2019 notification because it mentions these two specifically. Page 30A. Page 30A. What I am trying to do is I am trying to relate the law to the notification. Page 30A, first para. It has been decided that a similar payment methodology towards compensation shall be adopted in the state of Arunachal. These guidelines of payment methodology of compensation towards damages stipulated in section 67 and 68 of Electricity Act and 10 and 16 of Indian Telegraph Act shall be in addition to other this thing. So, Your Ladyship, this notification is under these acts. It lays down the rates. If you see, there is a table attached which says if it is 66 kVA, it will be 18 meters, 110 kVA, it will, the width, right of way width that they will compute will be 22 meters, things like that. And it also is very clear that this compensation is for diminution of land, which is duration of the property rights that are available to you after this is used. And the important thing is that the notification, the impugned notification is not mentioning any statute under which it is. It's arbitrary. That if there are people who have no recourse to any kind of compensation, they will get 50%. Fine. I mean, we have no problem with that, but we are not covered by it because we are people who do have rights. Now, all we want, Your Ladyship, is...
So this notification dated 29th August is as per the
Cabinet note.
the acts, so it is
No,
okay
it,
notification. But soon
yes.
after that,
Yes,
this is 29th, then.
the
soon
29th
after that,
August
on the
2019.
31st August,
Yeah.
another notification was issued by the same department.
Yes, no,
Both the same department.
Commissioner
Department
Power,
of
this is by
Power.
Commissioner Power. And
Both of them are from
Yes,
the
yes,
Department of
yes.
Power, isn't it? Which contradict
right.
each other.
That's
I think
right.
that's your point, isn't
yes,
it?
your leadership, not only do they contradict each other,
Huh.
the same notification contradicts itself. The article, the para 3 says something else and para 2 says something else. Para 3 clearly talks of people who have rights. I read again para 3 on page 29A. For identification of affected individuals where a right of way has been duly granted by the competent authority in reserved forest area. So these are people who have rights. But para 2 is talking of people who have no rights.
So you're saying, no, so this notification dated 31 August.
Yes.
Contradicts itself
Yeah.
and also contradicts the notification dated 29th August.
I wouldn't say
Is
it contradicts. All I say is that
Because it says full
it is not
compensation.
related to that. This notification is also the one on 29th August is for affected parties as
Okay.
per the law. This one is for people who have no recourse. So this is for people who, to the
Are
best
not
of our
affected.
knowledge, maybe tribals coming from Bihar and lost in Arunachal. So they only meet the criteria, they are tribals. But they really are not affected parties. 10 tribals come and do labor there and say we are also affected. Maybe they are, I don't know. But this kind of a notification can take care of them. But it does not take care of me, who is a genuine affected party, because no procedure for identifying me has been laid down or followed in pursuance of this notification. What has happened is I have been ignored from the process of assessment.
You have not been paid any compensation.
So that is secondary violation. First, I have to be in the list of people affected. So
you
no
have been
exercise has been
excluded.
carried out.
Okay.
All I want
This-
is let there be an exercise in the reserved forest area
So
to
as
identify
this
affected.
para 3, page
Yeah.
29A,
G. Yeah.
page 29A.
Yeah.
Okay. So here the notifications, they says that it has to identify the affected person.
Yes.
So you're saying that this exercise has to be carried out in respect of your
Yes.
case?
Yes.
Being one of them, okay.
Yes.
Oh.
Yes. That's
So
all we
once-
want.
Once the exercise is carried out and to see
Rest
whether
is
you are the
mathematical.
affected person.
Your leadership, the rest is mathematical. See, it's a 3-step process.
Uh-huh.
First, typically exercise is carried by what is called a walkthrough. Some team is created which walks through the area and people are asked to make their claims. Now those claims don't mean they will get the money. Those claims will be authenticated by the administration. And the claims may be of different kinds. Somebody may have LPC, somebody's LPC may have been cancelled, but he has the opportunity to reapply. Somebody has never got an LPC, but he's staying there. But during the walk, everybody will file their claim. That claim, based on the administrative order on those claims, will quantify the amount of compensation. That's mathematical. There is no leeway in that. That's purely mathematical. And that compensation, the Power Grid Corporation is bound to pay. There is nothing coming out of the state pocket. On the other hand, your ladyship, sorry. If people who are not affected are paid, actually Power Grid doesn't have authority to pay them. Because as per law, full payment has to be made to the affected parties.
So your claim is that you're affected and
We are
that
affected.
verification has to be done.
In my area, no walkthrough, no compensation estimate has been done because legal opinion has been taken, like I showed you, which says that in this area under the power, this act, Power Transmission Act, it is not necessary to do this. So based on that, the cabinet meeting, I think what happened, this I am surmising, the people in authority in the cabinet meeting realized that there is something wrong here. and these people have some rights. So para 4 clearly says that there are rights. So all I am saying is that, and this order has been given earlier by this court, honorable court. So, Your Ladyship, what I would like to do very quickly is, for clarity, is that I have prepared a short, whatever I have said, I have made a small written submission. I have, I should inform you one more thing, Your Ladyship. Last to last date, what had happened is we were approached by the administration for a meeting. And we did go to that meeting and we informed the court that such a meeting is taking place, which might deal with compensation. But in that meeting, 2 things happened. One is unofficially, of course, but it's my duty to bring it to your attention. Power Grid said, whatever is the compensation, we have no problem, we'll pay it. The problem is yours. The state has to decide, which is very true.
Identification.
Yeah, this is very true. And the commissioner concerned who was present in that meeting, he said, now that the matter is sub judice, I need a direction from the court. So there is a recognition that a faux pas has happened. This is a faux pas. It's not, there is no motive here. It is a faux pas. It has happened. All I need, Your Ladyship, is to protect me in the sense, whomsoever, let them do a walkthrough. Let them allow us to submit. Whosoever says this is my claim, in whatever format, let them give the claim. Those which are valid claims in the eyes of the administration, let them compute the compensation and pay them. Those are not valid. There is a procedure for that in the act itself. They can pursue that if need be. I mean, this is not the forum for executing or implementing civil rights. We are merely looking at the law as it is being violated, and we request that to be reinstated.
Okay.
That's it.
Yes.
First of all, let the petitioner be specific what he wants in the petition.
What is the prayer in the evict petition?
Yes, Madam.
Your prayer portion. If you're saying it's not specific, what is the prayer portion? What did you pray for?
His prayer is to set aside the notification, which now he is relying, that under that notification, his rights should be identified.
I'm not relying on. Ladyship, that's incorrect. I'm not relying on the notification. I'm merely pointing out the error in the notification.
So your prayer is in page 24.
Yes.
Isn't it?
Yes.
Setting aside the notification, then number 2 is directing the respondents to pay the land compensation as per the provisions of law. Then you've mentioned this. So there is a LPC application pending, is it, before the state authorities?
Some applications are pending, Your Ladyship. Some are issued. Some actually have been cancelled, but the court has said they have an option of, because some wrong procedure followed, they have an option of following the procedure and getting the LPC. Your Ladyship, I am not on the issue of actual rights of individuals. All I am saying is 2 things. Number 1, this notification can be harmoniously interpreted by Your Lordship also by removing the not entitlement thing and by saying that a due procedure for identifying affected parties may be followed. But I'm not depending on this notification. I'm depending on the law as I have just taken you. I am depending on the notification of 2019, which lays down the rate. And I am saying that as per the rate, depending on those of us who have come here have valid LPCs. But there may be others. So because the walkthrough will not happen for just few of us. What I want is very simple. I want identification of a process to be followed for identifying people whose rights are going to be touched upon in any way, either by right of way or by that pedestal which is made for that hour. That's all I mean. And I don't want to a stay order. I don't want to stop the work. I have no such. I never had. I never prayed for that.
My Lord,
Yes,
if that is the limited prayer, then my Lord will kindly see our affidavit. This entire process has been done. landowners, affected landowners have been identified. Their compensation also has been paid.
Where's the affidavit?
Affidavit, my lord. Government's affidavit. Affidavit filed by the respondent number 7.
This is respondent number 6. 6 or
7,
7?
7, my lord.
7, see?
This is in TCM, WPC 32.
Lordship, I am for 6 in both 32 and 78.
Okay,
Respondent, I'm for 6.
okay, let's
Sure.
listen to, let's hear 7 first, since it's already standing. Wait, let me see. Respondent affidavit by respondent number 7, yes.
My lord, may come to para 8, my lord.
Hmm.
May I read, my lord?
Hmm.
That with regards to the statement made in paragraph 9 of the writ petition, the answering deponent begs to state that the Deputy Commissioner cum District Collector Pakai Kesang District had issued an order dated 5th December 2023 for final ground verification for ascertaining genuine landowners under unclassified state forest area in the district. The follow are the details work carried out by the district administration in the unclassified state forest. 1. That as per order dated so and so, Itanagar 2nd June 2021 had issued notification regarding payment of compensation in unclassified state forest area to all affected landowners in the state. Second, in pursuant to the above government office memorandum, the Deputy Commissioner Pakai Kesang so and so, dated so and so, under the chairmanship of SDO so and so, Pakai Kesang for ground verification come a certain actual landowners and properties being likely to be damaged while construction of 132 kV transmission line under unclassified state forest while involving all stakeholders. This was done, Bharat. Ground surveyor. Thereafter, the Deputy Commissioner so and so forwarded a copy of notification to Secretary Power so and so for publication of notification and published in the newspaper on 10th August 2023, published under the provisions of Section 6, Section 8, and Section 164 of the Electricity Act 2003, Indian Telegraph Act 1885, Section 10, and Section 18 of the Government of Arunachal Pradesh notification by so and so, the Itanagar so and so. The payment of temporary damage in right of way in the USF land. This notification also, my lord. Thereafter, the board submitted compensation estimate as per ground survey and assessment, and the same was forwarded to the government of Arunachal Pradesh for approval. Accordingly, government has approved and deposited compensation amount of rupees 2,84,61,956 for payment of compensation to the genuine landowners in the unclassified state forest area in the district. That receipt of the compensation amount from the government, the Deputy Commissioner cum District Collector constituted final joint verification board by number so and so dated 5th December 2023 as to genuine landowner would not be deprived. Accordingly, a board submitted final list of genuine landowners for payment of compensation. Thereafter, that in compliance of the above order, the joint final verification board carried out ground verification and submitted name of genuine landowners for payment of compensation in the unclassified state forest in 2 circles, that is Pasa Valley and P. Jerang, to the Deputy Commissioner cum District Collector Lemni so and so. 2 reports were submitted for 2 circles, my lord. That by so and so, dated March 2024, a disbursement board was constituted for payment of compensation to the genuine landowners as per board recommendation. Then at 8, all genuine landowners had received their compensation from the district administration without any protest. Then finally, district administration has issued by working permission number so and so dated 16 May 2024 to the Power Grid Corporation Limited for start of work in the USF land. Now, my lord, first of all, without confusing the other legal points, my lord will kindly see.
So you said that you have done the due exercise.
Yes, my lord.
Oh,
My
okay.
lord will kindly see the page 54.
Hmm.
This is by recommendation has already been done by the board, my lord. Because through the towers through which it is going to pass, my lord, all these landowners have been identified, my lord. Whereas as per office memorandum white number so and so dated 2nd June 2021 issued by the Secretary Land Management, Government of Arunachal Pradesh, the district administration has carried out final identification of actual landowners with the help of PRIs, well, Panchayat Raj members and Gaon Buras of the concerned affected villages under Pejirang circle so and so so and so. Whereas in compliance of the office memorandum, this office issued white order number so and so dated limited 3rd November 2022. A board was constituted for summary proceedings under the chairmanship of Deputy Commissioner Pake Kesang for determination of compensation estimate of diminution of land and assets value being damaged temporarily during the construction of 132 kV transmission line in the district. And whereas in pursuant to of government order number so and so dated 3rd November 2023, diminution costs of land properties have been worked out by the board of committee for payment of compensation and temporary damages of land and assets of the route for construction of double circuit tower location for 132 kV SEPA reload transmission line. The project under comprehensive scheme for strengthening of transmission and distribution system, Arunachal Pradesh at, my lord, this is Sede, Dola, Vio, Tarior, and Pakro villages under Pejirang, Pejirang Circle, Pakekesang, so and so. Now, the government of Arunachal Pradesh by so and so, so and so. My lord, I'll not bother. Then the land name of this affected person starts at page 56.
56, huh?
Yes, all this 56 all together, my lord, will find in the last portion at page 64. This is total 67 total persons. Then in the table B, total landowners 67 numbers, total landowners verified 65, verified 65, total landowners not verified. Plot number 66 and 67 remarks is disputed on ownership. This was not verified. My lord has got page 64.
Yes.
Then total dispute on ownership. Plot numbers are given. These are total 11 in numbers because of ownership dispute. These are, everything has been found out, my lord. Everything has been done. Now this has been recommended by the board for this first circle, my lord, Pejirang circle. Now the second same date, my lord, recommendation of list of genuine at page 66. This is my lord will kindly see at the bottom. Yarte Pobe, Pasakem, Chambang, Nokleko, and Rilo villages under Pasa Valley Circle. My lord has seen page 66.
Yes, yes.
Here also, all genuine affected persons have been identified.
Shown us the steps taken by the
Yes,
state
identified.
government and
Proper
identified.
identification has been done,
Oh.
and they have been paid. There is no protest, no claims. Now, here also total 72 numbers in the second circle, my lord. They have received the payments, and that has been, this process has been completed, my lord. Now the petitioner.
How many petitioners?
Petitioners, my lord, will kindly see.
How many petitioners have come before this court? Any idea in the
May I
number?
answer that very quickly?
Uh,
May I answer that very quickly? Your ladyship, whatever he is saying, I agree with it is correct, it is 100% acceptable. But what he is not saying is important, but he did in passing mention. Whatever he has said is about USF, not RV, reserved forest. And he has paid full compensation there. The notification for UHF, the full compensation has been paid,
Yes.
85%. I take you to page 42 of his, what he was just talking.
But your.
We are
land
reserved
is
forest, we are resident. of
Regarding the
reserve
reserve forest.
And reserved forest is not covered by what he is talking about.
So this reserve forest area, it's within what district?
Pakke Kesan.
What was just mentioned here?
It is mentioned, we have mentioned. Your ladyship, the relevant point is that there are different types of forests. I am talking only about
Okay.
reserved forest.
Pakke Kasan district
Kasan.
reserve forest.
Yes.
Ah.
Your ladyship, the only relevant point is whatever he's saying is 100% correct. Except he's not answering my problem and he's not rebutting me also. When he says compensation has been paid, people have true, but in USF. And I take you to his submissions only. He very clearly says so in his submissions.
No, in the.
If you
listing
see
itself,
your
the order
notification,
itself, it
you take the
mentions-
notification on page 16, under which he has been paid. It's different from the notification under which I am laboring. Page 16 of his affidavit in opposition.
Page 16.
Page 16, 1-6.
Ah.
R7's counter affidavit. Your ladyship, notification 28 June 23. Read the second last para. Unclassified state forest. Also, read that the payment will be as per the 2019 notification, which is 100% payment.
So the issue is not regarding the unclassified state.
No, it is
forest,
not about that.
isn't
It is about
It is
reserved
about
forest.
the reserve
And reserved
forest.
forest, they have not even conducted a survey.
So let him listen. So regarding the reserve forest, have you mentioned in your counter affidavit?
They have not said anything that this is under the reserve forest. My lord, we have said that this is passing through the unclassified state forest.
Okay.
So the verification, compensation, everything has been done, given under the unclassified state forest, not as a reserve forest. Now,
So in that area, there are certain areas which are called the unclassified reserve forest.
yes,
Unclassified what? State forest.
yes,
Okay, unclassified
State
state
forest.
forest. Now, the claim of the petition is besides this area, which is denoted as unclassified state forest, there is also another portion, a
They-
part of the land which is
they have not said in the
denoted
repetition.
as the reserve forest, which has not been actually identified.
They have not stated anything as such in the repetition.
No, let's see, in your writ petition, has you
Yes.
mentioned reserve
Yes,
forest?
yes, your
Yes, yes.
ladyship, I have not only
Then-
mentioned, I have given the maps of the plot of the
No, but.
poles which are going
but-
to our
Mention.
properties.
But show me where you have.
That their
specifically
land falls
mentioned.
within the reserve forest.
No, that-
Let them mention that.
In your.
Your ladyship, I have
writ
mentioned, reserved
petition,
forest I have mentioned
because-
specifically. In fact, all the notifications I have shown you are for reserved
There
forest.
has to be a.
And the notification which they have paid under is a different notification I just now showed you.
Uh-huh.
And that was for,
Unclassified state forest.
that was for, yes, that was not for reserved forest.
That's why I was, before replying, I was asking the specific period. They have not said anything that their land falls under
Your
the reserve
ladyship, see
forest.
para 3, see para 3,
Yes, sir.
see para 3 of my petition.
Yes.
I am quoting.
Hmm.
Para 3, or let's say the humble petitioner beg to state that the government however through its Commissioner Department of Power Government issued a notification dated 31st August. The notice claims to declare a state policy titled Special Ex Gratia Relief Package towards Rights of Way for 132 television transmission line is passing through the reserved forest. I am talking only of reserved forest throughout your ladyship. And
This is, my lord will say, this is the abstract of the notification. Where is the statement that their land falls
this is
under
what
the
I am
reserve?
saying, that humble
But
petitioner beg to
but
state.
it is concerning this notification.
Yes,
which mentions the reserve forest.
yes.
So now we have to see whether both of you are on the same page regarding the area where
No.
the petitioner is claiming for compensation for a certain area which is termed as reserve forest.
Yes, madam.
And you have filed a counter affidavit regarding the steps taken by the state where the area is known as the unclassified state forest.
Yes, madam.
So we have to see whether you have addressed.
There
the-
is no pleading that their land is in the reserve forest, madam. My
Lordship,
lord will
I have-
kindly read para 3 again, my lord.
But in para 3.
Yes, my lord.
they have challenge the notification
Yes, my lord.
which mentions the reserve forest.
Yes, my lord.
Oh.
My lord will kindly see this 31st August 2023. This notification is being annexed, my lord.
So
this is-
31st
this is-
August it mentions reserve forest, isn't it?
Yes, my lord, this is the notification which he is challenging at page 29.
Oh.
This is the only thing, but he is not stating that his land is in the reserve forest. There is no mention. This is only a challenge made to this.
Your Ladyship, I have even included a satellite
There is-
map which is of the reserved forest area.
So I think the
And
counter
all
affidavit, the counter affidavit has not addressed to the points which are raised by the petitioner when he is concerned only with the area, because the petitioners are not saying that they're living within the unclassified state forest.
They are
Their
not
claim
even
is
saying that.
No, their claim is that since they are staying within the reserve forest, therefore they have challenged this notification. They have pointed out this notification, which refers to the reserve forest. Isn't it?
My lord, that's why there should be a specific pleadings that their land falls under the reserve forest. There is nothing. What their address also.
Then he should have not, then she should have not pointed out this notification.
Yes, my lord, then.
29.
Yes, my
Where
lord.
the page 29 here, it specifically mentions here the reserve forest. See, short title and commencement. Here again, it says through reserve forest. So if obviously he mentions this notification dated 31st August, then the area in this notification is reserve forest.
That is, my lord, if I'm not,
Come to page 29. So is there still an area known as reserve forest in that locality? We have to
reserve-
see, I don't know,
reserve forest is there.
huh?
But the transmission line is not passing through the reserve forest, it's passing through the unclassified state forest, and therefore it has been identified. People has been identified. Now, my lord, if they claim that they have a right under the reserve forest, my lord will kindly see their address. To establish a right under the reserve forest, under the Scheduled Tribe Forest Dwellers Act, my lord will kindly see their address
Where?
in this course title, my lord.
Okay, the course title.
A permanent, number one is Sri so and so, a permanent resident of Niti Darlong, POPS, Sejusa, so and so, so and so. Second is Nanya Golo, so and so, POPS, so and so, POPS Itanagar, B sector, so and so. Thomas Nabum, resident of Mobosu 1, POPS Sijosa, so and so. Sri Tarun Nabum, so and so, resident of village Sochung, POPS, so and so. So accordingly, now my lord, the definition of if scheduled tribe and what my learned friend has earlier shown. Who are the persons who are entitled to rights under the scheduled tribe and other?
So you're saying that they are not residents within the reserve forest?
Yes,
That's
my
what
lord.
the address given. I
What
think that's
the
your point. Huh?
definition 2C says,
Hmm.
forest dwelling scheduled tribes defines, means the members or community of the scheduled tribe who primarily resides in and who depend on the forest or forest land. Who primarily resides.
So your argument is that from the address, they are not residing in
Yes,
the forest.
and
land.
they have never not made a single statement that they are residing, they are the scheduled tribe dwellers in that forest land.
Okay.
There is no pleadings to that effect. Only saying that we have not been heard. These are, my lord, will kindly go through the entire pleadings. I have also not come through that what is their actual claim, my lord. That's why I was asking the counsel, what is his actual prayer? He should have stated that I am a scheduled tribe forest dweller who is under this forest, and the land is the transmission line is passing through my land. Just challenging a notification.
Okay.
My lord, therefore, what
You can, in rebuttal, you can answer
Yes,
it.
yes. What is, my lord, my respectful submission is what is pleaded in the petition that has to be adjudicated. What is not pleaded, what is not asked for, what is not prayed for, how can that be that relief be granted? There is no prayer. In fact, what his prayer is for identification of the beneficiaries under this Scheduled Tribe Forest Dwellers Act. He should have filed a specific, made a specific prayer for this. There is no statement to that effect. After affidavits are filed, now he's saying that no, I'm not concerned with the unclassified state forest. I'm concerned with the reserve forest. Whereas there is nothing in the entire writ petition saying that I am concerned only about the reserve forest. My land is, I reside in the reserve forest.
Anyways, continue.
So, my lord, this entire process has been completed. If they want to establish their right as a scheduled tribe forest dweller under this Scheduled Tribe Forest Dwellers Act, and if they are aggrieved by the notification of this 2023, they have to come with specific pleadings.
Okay, it's not included in the.
No,
pleadings,
it is not. What has been, they wanted to stall the process of land compensation. Now, this has been disbursed already, accepted by the union affected landowners. If they still want to try their luck in the reserve forest, claiming that this line is passing through the reserve forest and they have rights in the reserve forest, they would have to establish their right.
Okay, so you mean saying that the writ petition is not regarding the reserve forest area?
Yes, there is no specific, and for unclassified state forest, we have.
Okay, fine.
Yes.
Oh. In rebuttal, or should we hear the other respondents first?
I believe sir can rebuttal in one go to all of us, my lord. I may continue from where my colleague has left, if your lord, my lord permits me.
Yes.
We'll make
Respondent
it
number
easy.
6.
I'm for Power Grid Corporation of India Limited, respondent number 6.
Yes. Please go
Lordship, I am a government, I'm a public sector undertaking. I am an expert agency in the drawing of transmission lines and establishing transmission systems all across the country, and we have taken several projects overseas also.
Okay.
So, Lordship, straight coming to the case at hand, if I may have my lord's attention drawn to page 24.
Page 24 of the
writ petition.
Of the writ petition. Okay. Yes.
May I?
Yes, please go ahead.
Prayer 1. A writ in the nature of certiorari or any other appropriate writs, order or direction shall not be issued in setting aside and quashing the notice under dated 22/6/2020/31/8/23 issued by respondent number 3. This notice we will find it at annexure 1. I'll come to it, my lord. Prayer number 2. A writ of mandamus shall not be issued in directing their respondent authorities to pay the land compensation as per the provisions of the laws, including A, right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013, Electricity Act 2003, Indian Telegraph Act 1885. 3. A writ of mandamus shall not be issued in directing the respondent authorities to take cognizance of the LPC applications pending with the state administration and invite claims. Now, my lord, I will place my arguments in 3 compartments,
Yes.
all emanating, originating, and culminating with the prayer that they have done. It's a settled rule of pleading, my lord, that your prayer is the final outcome you are wanting based on what you have pleaded above. Now, in this whole prayer portion, my lord, we do not see any mention of what he is praying now. And I'm sorry to say, but yes, I'll make a statement that this is the 3rd round when we are arguing this same matter. And every time we argue it, sir comes up with a new set of arguments, new set of prayer, new set of demand, which is absolutely different and alien to what he has pleaded in his complaint. His writ petition is 100% different from what he is arguing. Thus, my lord, our counter affidavits can only address those issues or answer to those issues which were pleaded. We cannot sit and imagine what will be the next oral argument that my learned senior here will bring about when he is arguing the case. Now, my lord, let us come into the first prayer and to understand that if we may travel down to page 29, my lord, that is the notification that they are challenging. And my lord, at page 30A is the mother notification. That is notification dated 2019. For the sake of easy shuffling between the 2 notifications, my lord may permit me to say notification dated 2019. I will refer to page 30A, and notification dated 2023. I will refer to the one they are challenging. Now, my lord, to go back to understand these notifications and how did they come about, we will have to go to the genesis of it. Now, we will not travel as far back as sir is wanting to take us to the Constitution. Let us understand how they came about, my lord. If I can have, my lord, at 164 of the Indian Electricity Act.
Yes.
Now, under 164 of the Indian Electricity Act, my lord,
Section.
Section 164. We may glance it once, my lord. It says conferring the powers of the Telegraph Act.
Okay, Telegraph Authority. Okay.
My lord. So in exercise of these powers, why the notification of 2003, my lord, the central government had bestowed the powers of Part 3 of the Indian Electricity Act upon us. To be very specific, in my counter affidavit, my lord, it is there at Annexure 1, page 23. Notification dated 24th December 2023. The central government, in exercise of the powers as conferred under Section 164 of the Indian Electricity Act 2003, bestowed the powers of the Telegraph Authority, which they exercise under the Telegraph Act, but only confined to Part 3, my lord.
Yes.
Now, my lord, if we may travel down to the Indian Telegraph Act, Part 3 deals with sections 10 till section 19B. Now, my lord, our primary concern here would be only section 10 because that is what will shed clarity on the issue at
Section
hand.
10. Okay.
10, my lord. And in specific section 10B. May I, my lord? My lord,
Yes.
if we are at section, if I can have my lord's
Yes,
attention
go
to
ahead.
section 10. Yes. Power of telegraph authority to place and maintain telegraph lines and posts. Now, over here, since these powers have been given to me, my lord, wherever the word telegraph authority is being used, it has to be interpreted as power grid. My lord, it says at 10B, the central government shall not acquire, that is me, I will not acquire any right other than that of the user. So that is answering one of the prayers of the petitioner, where he says that the land compensation should be given after acquisition of the land when he's talking about the 2013 Act, my lord. It
So you're
says
the user.
I will only acquire the right of a user, my lord. There is no land acquisition which happens while laying down transmission line, be it over an individual's property. So the forest land he's saying that I will acquire it and pay him compensation as per the 2013 Land Acquisition, Rehabilitation and Settled Fair Compensation Act. I will come to it how it is not
Okay,
applicable.
so you're only the user and you have not acquired the land.
We know there is the law is 100% settled. I am only a user.
Okay.
So now my lord, section 10 says 10D. 10D says, it continues now, in exercise of the powers conferred by this section, the telegraph authority shall do as little damage as possible, and when it has exercised those powers in any property other than those referred in clause C, shall pay full compensation to all persons interested. Now, this is very important, my lord. They will say the word full compensation. Full compensation is a lost word here. It will come to life when we read the next two words, for any damage sustained by them. My lord. So, I will not acquire any land. I
Okay,
am
so it's
only a
only
user.
if there's any damage. So you're saying only if there's any damage.
Compensation only for damage.
Oh.
So, my lord, now the acronym which is used for this damage is known as tree crop surface damage compensation.
Okay, where's that?
The word, my lord, any damage sustained has been interpreted by various courts and judgments. The damage for which I'm paying compensation is for tree crop and surface damage. Now what happened in 2015, my lord, the central government understands that the compensatory amount which we were paying until now in the form of tree crop and surface damage, that is under the Indian Telegraph Act, was not at par with what should actually have been paid in the present era. So the government of India, my lord, in 2015 issued a notification. Basically, they issued a guideline. If my lord may please come to page 27.
Of your counter affidavit or what? Of what?
No, my lord, we will, my lord, I'll sum it up from here only. At page 30A of their
Of what?
affidavit.
Of their
writ
affidavit.
petition. Writ petition, my lord.
Page
30A.
30A.
30 alpha.
Yeah. Yes.
Now, my lord, it says that, now, my lord, I will give a backdrop on it. Now, what happens is the government, when they see that the only form of compensation which was being paid under the Telegraph Act, that is tree crop and surface damage, is not sufficient. So they come up and say that, no, we will also include two more aspects for payment of compensation. Now, among that aspect, my lord, in 2015, third line in this particular notification makes reference to it. The central government, they formulate certain guidelines, but do not implement them. They say that we will leave the implementation to the state when they adopt. Accordingly, Arunachal Pradesh adopted it, my lord, if I may read the lines. The governor of Arunachal Pradesh is pleased to adopt and notify the following rates for payment of compensation towards damages in regard to right of way for the transmission lines in accordance with the guidelines of Ministry of Power, Government of India, wide reference number 03/07/2015 transmission trans dated 15/10/2015 for maintaining uniformity in compensation payment. My lord, the next words are very important. To the affected land owners during the construction of transmission lines.
Yes, affected landowners, huh?
Affected landowners,
Oh,
my lord.
okay.
And it goes on to say that this is an addition, my lord, to the compensation which was being paid under Section 10 and Section 16 of the Indian Telegraph Act. Once I am done with this, my lord, I will draw my lord to Section 16 also to say why 16 comes into play. So it is very clear. Now, this says, my lord, if my lord may travel down to clause 1 and clause 2, it says, and my lord may make a note of these two numbers. It will be important to understand. It says compensation at the rate 85% of the land value is determined by district magistrate or any other competent authority based on government approved rate, circle rate. B, compensation towards diminution of land value in the width of right of way corridor due to laying of transmission line and imposing certain restriction at a maximum rate of 15% of the land value. So the government says, in addition, my lord, to the surface damage and tree crop compensation, which you are paying under Section 10D of the Indian Electricity Telegraph Act, it says you will also pay an added compensation in the form of 85% of the tower base area rate and 15% for the ROW. Now, my lord, this was the Arunachal Pradesh government has adopted exactly the guidelines as were given by the central government. Now, my lord, state of Mizoram to mention, the state of Mizoram has not adopted the guideline exactly as the central government gave in 2015. State of Mizoram, my lord, has gone a step ahead and they said, no, it will be 100% in the compensatory rate. So that was the state's criteria. Now, my lord, let us come back to the notification for which they are saying is illegal and it should be done away with. Two pages prior to it, my lord, page 29. May I, my lord?
Yes.
Read it. Notification dated 31st August. I have my lord on that. My lord, it says, in the interest of public service, the governor of Arunachal Pradesh is pleased to notify the special ex gratia relief package towards right of way for 132 kV transmission lines passing through reserve forest under the comprehensive scheme for strengthening of transmission and distribution system in Arunachal Pradesh policy. For the purpose of facilitating completion of the statewide project for socio-economic development, the state of Arunachal Pradesh as under subtitle and commencement, this policy may be called the special ex gratia relief package towards right of way for 132 kV transmission line passing through reserve forest under the comprehensive scheme for strengthening of the transmission and distribution system in Arunachal Pradesh 2023. It shall come into force on the date of its issue and remain effective until further orders. Very important, my lord. Clause 2A. For the tribal population as identified in para 3 of this policy, who are not entitled for any benefits, including compensation of specific nature, resettlement or rehabilitation, and ex gratia relief package amount equivalent to half of the rate notified by notification of 2019, my lord, would be payable. Now, my lord, what do I understand of it? Central government in 2015 gave a guideline. Arunachal Pradesh adopted it in 2019 and implemented it. Now, when another particular project is going on, the state government it is their goodwill gesture, my lord.
I'm getting your point.
Because-
Those who are not entitled to, who would be these people?
No, these are the people which the state government will identify, my lord. I am the implementing agency of a project because of the expertise I carry. I am not the person who sits on the chair to make a policy decision. But I am duty bound when my learned senior here is wrongly interpreted the whole of the Electricity Act, the whole of the compensation payment mechanism. So it is my duty to bring it out to my lord. That is why these numbers come at 42.5%, which is exactly 50% of 85%, my lord. And 7.5%, which is exactly 50% of 15%, my lord. So the state government said that we will implement this goodwill policy. My lord, they themselves say, for the tribal population as identified in para 3 of this policy, who are not entitled for any benefits, including compensation of specific nature. To them we will give. Now at para 3 they say, my lord, next page, for identification of the affected individuals where ROW have been duly granted by the competent authority in reserve forest area, board of officers shall be constituted by the deputy commissioner concerned at the district level, akin to the board constituted in matters related to the land acquisition. The representative of the forest department shall be necessarily included in such boards for identification of the persons. Now it is very clear, my lord, when they say. So if now I have two questions to myself, my lord, which I don't find an answer to.
No, so
First,
you're
they
saying
challenge-
that, wait, let me just clarify.
My
So
lord,
you're
my lord.
saying that this para 3 is with reference to the identification made in para 2. Is it?
My lord, para 3 say, my lord, para 2 is saying that who will be the people entitled to? Para 2 opens up and says, for the tribal population as identified in para 3. Now, para 3 is the mechanism of identification, my lord.
So it's
my lord,
referring to those persons who are not actually entitled to any benefits.
they are not entitled to benefits, they are not landowners, but they are people who are dependent on that forest for their livelihood. That is how I interpret it, my lord. But my learned friend here, Sir Additional Advocate General, Mr. Ratan, will be able to draw a better light on it. May I continue, my lord?
Okay, wait, let's clarify this point, isn't it?
My
So
lord.
in
My lord, why?
under para 2, it appears that the right of way, okay, it's not through their land or anything, but they have been affected.
My lord, why the word who are not
Entitled.
entitled to? Because
Who are these
under the forest, reserve forest, no one has any specific right. Apart from the rights which are conferred under the scheduled tribe forest dwellers. They cannot own land. No one can own land in a reserve forest.
Yes, they cannot have ownership.
Yes, they can be given certain rights under the Scheduled Tribe Forest Dwellers Act. Therefore, even though they are not entitled for any compensation, but because of the rights, that's why the who are not entitled for compensation. The word
Who are not entitled for compensation on the land acquisition, is it?
no,
No,
who are
my
not
lord, no.
my lord, who are not entitled for compensation. Any compensation, but since they have a right under the Scheduled Tribe, this Forest Dwellers Act, they are given certain compensation, right? Because they have a right of passage and all. For them, since those rights will be infringed, that's why a minimum compensation, because they don't have a right over the land.
Okay.
They don't have any right
Being
of
within the
ownership
reserve forest,
over the forest land.
No.
No ownership right over the forest land, but certain rights to collect firewoods, other rights, but not a ownership right over the forest land. That's why they have said it is termed those who are not entitled.
Okay.
That
Primarily, my lord, to ensure that the right people are being reached out to, the para 3, my lord, it says representative of the forest department shall be necessarily included in such board for identification of persons. I believe, my lord, that actually sums up the intention of the legislature when they were formulating it. That not even a deputy commissioner alone will do it, but actually people from the forest department shall necessarily be included in that board, my lord, to identify it. Now, my lord, I have two questions I can't find an answer to. First, they are challenging this notification when this is a goodwill measure given by the government, not out of necessity of law, but because of a social welfare measure. And then they stand up themselves and they say that please start identifying us under this notification. So in their prayer, they say quash it. In their oral pleadings, they say please start identifying us under it. Now, my lord, if I hope I'm being able to convey, my lord, the points in the electricity, because they sometimes become little. My lord, now to understand, if my lord can, if I may have my lord at the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act. My lord, if we can go to section 105 of the Act.
Anyway, just read because the Act is not there, but what portion of the Act?
My lord, section 105 of the Act very categorically states, my lord, that provisions of this Act not to apply in certain cases.
Okay, in what cases? Where's the Act? 2013, Right to Fair Compensation.
Fair compensation.
Oh.
Till the time the Act is coming, now, my lord, I don't know if a person who's claiming that he is a forest dweller and then he's saying that I've applied for a LPC for the forest land. I don't know if forest land people can have an LPC in forest land. Again, my learned brother Ratan here would be able to share better light on it, but my general knowledge and ordinary prudence says that you cannot have any form of a title document in a forest land.
Yes, 105.
105, my lord, section.
Yes.
Now it says that it will not be applicable in certain cases, and it has spoken about Schedule 4, my lord. Now, if my lord can go to Schedule 4, it will be towards the end of the Act.
Yes.
Entry number 12, my lord. These are the certain Electricity Act. Now, it is under which I'm working. So, my lord, what they are praying for is barred by law. Now, what they are arguing is something they have not pleaded and they do not know. They have not once at anywhere said that we have not been surveyed or the survey was, verification was wrong. They have not said. My lord, if they so much so, they should have challenged the board which has identified the people. The affidavit by the state, which we have been privy to, my lord, a few minutes ago, they say that some 2 odd crore rupees has been dispersed and the affected people were identified by the board. The petitioners herein, my lord, they have not challenged it. So only by coming and I'm sorry, but my lord, I believe I have been able to convince and show, my lord, what is the actual position of law and how the compensation mechanism operates with regards to the Electricity Act. And it's when we are exercising powers under it, my lord, and the Telegraph Act. And the way petitioners are trying to interpret the law and the whole ecosystem surrounding the Electricity Act and the implementation, my lord, I'm sorry, but then that is something which is not, it's not just alien to law. It does not endorse the seal of the courts. It's wide. There are, my lord, I can go on for days and days with the judgments that Supreme Court has come up. So, my lord, they don't have a case with them. My lord, I have been able to demonstrate only from the prayer itself They are saying that the 31st August 2023 guidelines should be quashed. But why should it be quashed?
Okay, since it's a goodwill notification, isn't it? Huh.
My lord, it is. Why should it be
Okay,
quashed?
okay, yes, okay.
The
Yes,
second
got your
aspect,
point.
right to fair compensation. It doesn't have any binding on
It's
me.
not applicable in this matter,
It is
huh?
not
Okay.
it is not applicable. The
Yes,
Indian Electricity
then?
Act, my lord. Now, as per Indian Electricity Act, my lord, I will be constrained to follow the Indian Telegraph Act for payment. When I'm following the Indian Telegraph Act, my lord, I am only paying for surface damage and tree crop compensation. And this compensation will only and only be paid to the landowner, my lord. It cannot be paid to anybody else. And finally, my lord, which I had told that I will come to section 16 at last to understand the concept of landowner, my lord. Why only landowner? If I can have, my lord, that section 16(3) of the Indian Telegraph Act.
Yes.
My lord, 16(4) opens up and says, my lord, 16(3) first of all says that if there is any dispute with regards to the sufficiency of compensation, the aggrieved person may approach the concerned court of law. But section 16(4) says, if any dispute arises as to the persons entitled to receive compensation, my lord, I will pay the compensation in the court, and those two persons can battle it out in the court, that whoever wins will get the money. Now, what I'm trying to interpret and bring before my lord is that Section 10 will only keep me, Electricity Act and Telegraph Act will only keep me confined to the landowner, my lord.
Okay.
So they are not the landowners, the petitioners. And the 2019 notification also is in line with, my lord, it is with the Telegraph Act and the Indian Electricity Act. That is why it says, when it opens up, concerned landowners, my lord, that which, my lord, we have gone through at line number 5, my lord. It very clearly says, for maintaining uniformity in compensation payment to the affected landowners during construction of transmission line, 2019, my lord, notification. Notification. Section 16 is to demonstrate your, my lord, that it is only for landowners, not for anyone else. Page 38.
Yes.
It says, my lord, line number 4. If I may, for maintaining uniformity in payment or to the for maintaining uniformity in compensation payment to the affected landowners during construction of transmission line.
Yes.
So, my lord, if they are landowner, they will have to demonstrate that they are the landowners. And once they have demonstrated they are the landowners, they are entitled for compensation, my lord. Once verified by the district administration. So if they are talking about the Indian Electricity Act and the Telegraph Act, they will have to demonstrate they are landowners. And if they are saying, because one part of their argument is also that today they made a new argument that they should be held in equality with the 2019 notification. So they have to show they are landowners. Now, today they again say, now they are saying, my lord, at the concluding part, they say that they should also be verified in terms of 2023 notification. My lord, the same notification which they have challenged and asking my lord to quash it. Now they are saying to identify them, and my lord, they cannot blow hot and cold. They are confused themselves. What do they want? Or who are they basically? First, they say they are forest dwellers. My learned friend here has demonstrated by their own cause title that their addresses are addresses anything but apart from the forest. And not that of one or two, my lord, but that of everybody. So, my lord, the case is devoid of merit.
Yes, go ahead.
My lord, we will have to confine ourselves to the pleadings, my lord. This is the golden rule of pleading, my lord. We cannot introduce something new at the drop of a hat from what they have actually pleaded. So, my lord, confining ourselves to those pleadings, their prayers are such, my lord, which cannot be addressed in the present form. So, my lord, being devoid of merit, my lord, the writ has to be dismissed, not this 32, but along with it, my lord, WPC number 78 also. And if they have actually some grievance, my lord, let them cast a proper petition with a proper prayer and come before the court, my lord, because if we are legally entitled to pay, we shall pay. And also, my lord, my last submission, I'm concluding, my lord. They also made a averment, my lord, that there was a meeting which was held and Power Grid has given them some suggestion. My lord, I have no such instruction. If my learned senior here is making a submission, he may file an affidavit to the effect. Because we will never make any kind of loose statements or assertions that we will pay you the compensation. Let the state tell us. No, my lord.
I think
We
that
are an
was made
agent.
outside for just some information.
My lord, none of my
No
officials.
affidavit is required.
My lord, none
It's
of my
not in the
officials
form
will
of
ever
an
make a
affidavit.
statement like that. My lord, we have not made any of those assertions. But my lord, to conclude, there is a very systematic way how we pay compensation. My lord, this particular project, it is not just in Arunachal we are implementing it all over Northeast. In Arunachal and Sikkim, my lord, because of the Chinese stand, we are calling it comprehensive scheme. Some international issues, my lord, because it is also partly funded by the World Bank. In the remaining states of Northeast, including Meghalaya, Assam, Mizoram, Nagaland, we are calling it NERP SIP, Intragrid Strengthening Project, my lord. So everywhere it is the Deputy Commissioner's office who will identify will fixate the rate, my lord, because it is their domain. The affected people are identified by the concerned district state administration, my lord, that these are the people who are affected, and accordingly, my lord, the compensatory amounts are paid. But this particular writ, my lord, with the prayers that they have casted, and I have been able to demonstrate, I believe, my lord, to my lord's satisfaction, that there is no relief which can be granted. My lord, I rest my submission, my lord.
I've got your point on that. No relief
my
can be
lord,
granted because of the prayer portion. Yes.
My lord, relief has to be what is prayed only can be given.
Okay.
So, my lord, if there is any query which my lord would like me to address it.
It's okay. I've noted your points. I think it's understood.
My lord.
Yes.
My lord, I am obliged for the patient hearing my lord has given me. Thank you, my lord.
Now in rebuttal.
Your Ladyship, my learned friends have done everything but address my concern and of course question me at very base level in the sense that they don't seem to find the difference in focus in what I am saying and what they are saying. What they are saying is right. Except where it concerns me, it's 100% right. Where it concerns me, it misses the mark. My humble submission to your lordship is to open page 16 in the R7 counter affidavit in opposition, R7, page 16. And
yes, respondent number 7, page 16.
And page 16 in the R7, this is a notification 28th June. Page 16.
Yes.
Notification of 28th June. Your Ladyship, I would trouble you to simultaneously open my writ petition 32 on page 29. On page 29. Simultaneously, Your Ladyship. Page 29,
Yes.
that is the impugned notification. Your Ladyship, this impugned notification on page 29, 31st August 23, para 2 says, it is referring to lines passing through reserved forest under the comprehensive scheme. It is about reserved forest. I am in my petition focused only on the reserved forest. Kindly look at the notification on 28 June 23 on page 16. Look at the second last para. This matter concerns unclassified state forests.
Yes, okay.
Now, Ladyship, they are apples and oranges. Their entire exercise has been to pay full compensation to people in unclassified state forests as per this notification. And as per the 31st August notification, pay 50% to people who have no rights
The reserve forest.
in reserved forest. And I have been arguing myself blue, saying in the face, saying that there is a contradiction in this order, because in para 3, it talks of identifying the people affected, whereas in para 2, it talks of people who have no rights. Affected people have rights as per FRA Act. The mention of Land Acquisition Act is only for the limited purpose of ensuring it is not left out, because in para 3, the language uses board constituted in matters related to land acquisition. It is similar. In my presentation before your lordship in the morning, I said very clearly, this is not land acquisition. This is akin to land acquisition as per their own notification. It is not land acquisition. I use the word deterioration of the property rights. That is what they compensate for, both in the right of way and also in the base. So, we are not talking about acquisition, land acquisition. We are talking about the compensation as per the law. Now, your ladyship, if you look at my para 3 and 4, in para 3, I have talked about reserve forest, quoting their listing. In para 4, notice dated was issued by the government of Arunachal Pradesh. Again, I am mentioning reserved forest. And then, your ladyship, I have attached a map which shows the plotting covering the areas where we have properties. My learned friend doesn't seem to know that LPCs after 2006 Act, FRA Act, are issued in reserved forest. And the ones we have attached are in reserved forest. They are not in some undefined forest. Now, if you see para 6, your ladyship, para 6 in my petition, it very clearly mentions that the petitioner has LPCs in accordance with provisions of FRA 2006. Very clearly. Then, your ladyship, there is a mention of a public meeting held for which minutes have been attached. Again, in para 8, I am talking of diminution of properties. We are not talking of land acquisition. So, words are being put into our mouth and then arguments placed for a pretty long narrative to build. Then, your ladyship, para 14. That the aforesaid policy has declared is also against the decision of cabinet meeting held on 18 July, which clearly states the Forest Rights Act 2006 must be upheld. I had taken your lordship to the cabinet note.
Yes.
Para 4 clearly says that. Then even my problem, your ladyship, is my learned friend is very right. We will get compensation only if we have some kind of land rights. Very true. The problem is I am being denied the opportunity of demonstrating I have a land right, which I have under FRA Act of 2006. All I am asking is that akin to the notification 20th June 23 for the unclassified state forests, where a process of identification has been carried out by doing a walkthrough, by issuing notifications, that has been denied to me because I am in reserved forest.
Yes.
All I am asking is reserved forest should be given the same right. I'm not talking of land acquisition. I'm not talking of, and the right, when I say it should be the same right, the compensation should be the same. Here, the compensation has arbitrarily been made 50%. It is not out of love and affection and giving us something extra. It is actually to deny our rights. And there is one more issue, Your Ladyship, I want to bring to your attention as an experienced person when you have undefined people with rights, chance of leakage is huge. You know, this creates undefined people with compensatory rights. But when there are people who are identified, money will go to where it should go. And also, when people are undefined, actually under the law, then there has to be a well-defined mechanism of asking for those funds to be claimed from whichever agency. As per the law, they cannot give funds to undefined people who have not suffered. I showed your lordship the law. Only those people who have, and very rightly my learned friend said, only those who have land rights and have suffered can get something. That's all, but they will get 100% of whatever others. Article 14, your lordship, equal protection, equality before law, that's one part. The second part we often forget, even on the bench sometimes, and sometimes the bar, because we are not reminding or helping our judges sometimes. It's not just equality before law, it's also equal protection of laws. Now here, your lordship, there are two sets of people. One in forests, which are reserved forest classified, one in unclassified. So the unclassified are being different rights, and the ones in classified for reserved forests are being given different. Lordship, I humbly submit this anomaly must be removed. That's all.
Before my friend gets his submission recorded, that his client's lands are under the LPC's forest land, he better take instruction, complete instruction, because for applying for LPC, land possession certificate, there has to be a NOC from the forest department that the land does not fall under the reserve forest. So
So
the land
2016 Act.
2006 Forest Act, he's saying.
Yes, it's 2006.
The process of issuing
Within
land
the
possession
reserve
certificate
forest,
in the state, my lord, it cannot be issued under a reserve forest. It can be issued for lands which are under private owners under unclassified state forest, but not under a reserve forest. If his submission is that
So we look at the 2006 Act and see.
6X is the Forest Dwellers Act, what he said. And
Not
our
Forest Act.
yes, not the Forest Act. There is no, Forest Act
Dwellers
called
Act.
2000. He is referring to the Scheduled Tribe Forest Dwellers Act 2006. There is no Forest Act 2006 apart from that, my lord.
FRA 2006, the commonly used term.
Yes,
for the
yes.
2006 Act.
Yes. And even then, what the main issue is that if he claims that his land is under the forest and he has applied for LPC also, then he, instead of getting the rights, he will lose his land also. Because the land, forest land, no LPC can be issued in forest land. Therefore, the entire,
as many as several years ago.
yes,
there were
reserve
as
under the
many-
reserve forest.
There was as many as 200 and something LPCs issued in this area where these posts are coming up. And they were cancelled by a petition, by a writ petition, which I was reading, So very much, there is a limit, your ladyship. I don't remember the limits, 2 acres or 4 acres, something like that. One LPC can be only that much. And if you see, your ladyship, in the act, if you see, it talks of alienation also. In the act, if you see para 4.
Para 4.
Para
A
4.
section must be.
Section 4, that is, I'm sorry, I use para sometimes. Section 4. Section 4.
Hmm.
Now, section 4,
What is
if you
it
see,
say?
it talks of section 4(3).
Hmm.
You go down to 3. Section 4(3).
Yes.
It says the recognition vesting of forest under this act to the forest dwelling children and other dwellers in relation state union, forest land, their habitat shall be subject to condition that such children, communities or other traditional had occupied forest land before 2005. That is one condition. A right conferred by itne shall be inheritable, heritable, but not. It's like your lordship. In the plains, you have scheduled caste properties. They are allotted, they are inheritable, they have property rights. If they are taken over by the government, the compensation will be paid, but they are not alienable.
So you're
Stay
saying
with
you
us.
have LPC over the.
Yes, yes, your ladyship, and multiple LPCs, not one. And there are a
I
lot
mean,
of.
the present petition.
Yes, yes, there are plenty of LPCs.
My lord, then his submission may be recorded that
Yes,
his
yes.
LPC is under the reserve forest.
In the reserved forest, my client has given me his LPCs and recorded, he signed the affidavit, your ladyship.
Oh,
It's
so
already
there
on
in the
record.
Affidavit, huh?
If you see para 6
Oh.
of my affidavit, LPCs are on record, it's signed by my client. I mean, I'm saying what he has told me. Rishi, I have also given you written submission.
The only-
This thing.
No,
fine.
no LPC can be issued under a reserve forest.
That's your submission.
Yes, and if they are claiming on the basis of LPC which have been cancelled,
Should be cancelled then.
no,
That's right.
no, that has already
Some
been
have been
cancelled. my lord.
cancelled.
Those have
They were
already been
cancelled.
cancelled.
They were cancelled by my efforts only.
They have already been cancelled.
Yes, yes, by my
My lord,
efforts.
they cannot even rely on this.
So they no longer have an LPC.
Yes.
Some don't have, some
No.
have, and
Yes.
some have pending applications. And
So
some,
now your submissions.
yeah. My submissions
Submissions
are-
made by you have given a gist.
Yeah.
Okay, now learned counsel for respondent number 6, you have referred to your counter affidavit.
Counter affidavit, we had
7, okay?
identified.
Now respondent number 6, your
lord.
submissions made, have it been mentioned in your counter affidavit?
My lord,
Okay.
absolutely, they are there in my counter affidavit.
Okay.
My
Then
submissions
I
may
will
be,
not make the
uh,
dictation in
yeah,
court concerning your, we'll make
My
it a
lord.
CAB, I think.
My
because
lord,
it's
only
already
thing-
quite late.
Only thing, the submissions are made before my lord, maybe they are not so elaborate in explaining the section, but everything has been mentioned in
It's
my
there.
counter affidavit. my lord.
Because
It's there.
we'll have to record your submissions. If it wasn't for paucity of time, I would have mentioned your submissions, but if it's all there, I think I can depend on that.
Yes.
My
Yes.
lord.
Much obliged, your ladyship.
Then heard, Mr.
Abhay Kashyap.
Yeah, A. Kashyap, is it? Learned counsel for the petitioner. Full stop. Also heard Mr. So-and-so, learned, government additional AG.
Yes, ma'am.
No, for the state respondents and Mr.
Khera, my lord.
Nitin
Nit-
Khera.
Nitin Khera.
Khera, learned
My lord.
counsel for respondent number 6. Hearing is concluded. Matter is reserved for order. Judgment.
My lord, for both 32 and 78.
Yeah, both are
the-
absolutely
the same.
same. Both the orders.
Same, same, same.
So they can be disposed
Yes,
of
yes,
by a
together,
common
by a
judgment
single-
order.
My lord.
He's for the power department and land department.
So you're depending on the submissions made by respondent number 7. Okay, you can mention their names. Okay. Yes.
Obliged, madam.
Highly obliged, my lord.
Oh, yes, this one understood matter.
My lord, I may be permitted to leave. I may be permitted to leave, my lord.
Yes, yes, please.
May I please, Lordship? Lordship, here in this case, I am on behalf of the petitioner. Lordship, I would like to withdraw the present writ petition.
Why? What happened?
Lordship,
Petitioners no longer want to pursue the matter or
Yes.
their grievance has been
No.
addressed to?
No longer wanted to pursue the matter.
Interested.
Yes.
Okay. Heard, Mr.
Titaba.
B. Taba.
Titaba.
B. Taba, learned counsel, T. Taba.
Yes.
Learned counsel for the petitioner. Also heard Mr. Yes, government advocate.
Yes.
Okay, learned government advocate for the state respondents. The learned counsel for the petitioner submits that he may be allowed to withdraw the instant writ petition since the petitioners in the writ petition are no longer interested to pursue the matter. In view of the above, as prayed for, the WPC number 247/2024 stands closed on withdrawal made by the learned counsel for the petitioner and accordingly stands disposed of.
Deeply obliged.